Report of the Public Order Bill, Lord Sharp of Epsom.
I beg to move that this bill now be considered on report.
The question is that this report be now received. As many as are of that opinion will say content. The contrary not content. The contents have it. Before Clause 1, Amendment 1, Lord Coker.
My Lords, can I start by saying I'm very grateful, because I thought I just lost the whole lot then without moving anything at all. My Lords, can I start the consideration of the report stage of this bill by moving my amendment number 1, and can I thank Baroness Jones, Lord Paddock and Baroness Chakrabarty for their support for this amendment regarding serious disruption and its meaning and relevance to this bill's new powers. Can I also start by thanking the Minister for his courtesy and for his usual help in trying to discuss the bill and its relevant parts. He's been very gratefully received, and can I thank him for that and all of his officials and other ministers. But in thanking the Minister, let me say how disappointed I was by the Minister in the other place, who said in an online article in the Telegraph over the weekend, "Our job as politicians of all colours is to stand up for the law-abiding majority where lives were seriously disrupted by such protests." My Lords, who doesn't want to stand up for the law-abiding majority? I have never said in any of the debates on this bill that the government, or anyone who is opposed or will oppose what I say, as wanting to ban protest or to accuse any of them of being against the law-abiding majority. This is a genuine debate, a genuine discussion between people of different parties and across this House on very serious issues where we are seeking to improve and amend the bill. And there will be differences of opinion, but that doesn't mean people are against the law-abiding majority, and that doesn't mean that people are not in favour of protest. The debate is about clarity, about thresholds, about where we draw the line. Democracy at its best, thrashing out these issues, and yes, voting in the best traditions of a revising chamber. It is my contention and my party and others from other parties and others across the House that the bill has gone too far. My amendment to have a higher threshold than that of other amendments, such as Amendment 5, but there are others, risks the police, in my view and others' view, being given lots of new powers, which instead of providing clarity, end up undermining and clamping down on peaceful and legitimate protest. So my Amendment 1 says that serious disruption must cause significant harm to persons, organisations or the life of communities, in particular in certain situations, but not exclusively in those situations. Keeping the threshold at a relatively high level, not lowering them. The EHRC saying in an article published today, these new amendments have the potential to enable the police to block peaceful protest or to shut down non-disruptive protests. My Lords, I won't go through every amendment in this group tabled by the noble Lord Hope, supported by the government. But if we look at Amendment 5, the language is much the same in Amendment 5 as it is in many of the other amendments, seeking legal clarity and definitions which are offence-specific. But if we take Amendment 5 as an example, this relates to locking on, which means attaching yourself to a person, object or land as set out in Clause 1. No definition of attach, so it can be linking arms. And then Clause 1 goes on to say the offence happens if this causes or is capable of causing serious disruption. My Lords, I want all of us to consider that when we decide how we should vote on these matters. In other words, some of the specifics around these amendments, you have to remember that an offence doesn't even have to happen, it has to just be capable of happening. And that should, I think, trouble us all. Amendment 5 uses a threshold where it uses language like it prevents or hinders to more than a minor degree the individuals or organisations carrying out their daily activities. The same threshold is set for all of the offences in clauses 1, 3 and 4. Goodness me, I don't know about many of the others of you in this house, in this chamber, or indeed watching these proceedings, But many of us would have been arrested or fall foul of the law under these provisions. Let me give one example from my own background, without going into the miners' strike, which I sometimes do more recently than that. I, along with a community group, stopped a bus going down a road which had been rerouted by the bus company. Rerouted by the bus company. It had been rerouted through an estate where there were children's play areas, parks, etc. And many of that community determined to act together because they decided that the bus company was acting in a way which is irresponsible to the lives of that community and put children's lives at risk. And so we blockaded the road, if you like. We linked arms across the road. We linked arms across the road and stopped the bus coming down that road for a few days. And as a result, the bus company changed the route back to where it had originally gone. So I say that this bill would have threatened that activity, threatened that protest, made it unlikely that me, yes, as a politician, as a councillor representing that area, but mothers, parents, grandmothers, grandfathers, friends with their children using pushchairs to stand in the road would not have been able to do that because it was more than a minor hindrance to those people. It stopped that bus going down the road. And who's to say that was wrong? But who can also say that if we pass these amendments, that that would not be made inappropriate? But don't take my word for it. I stand here as a Labour politician, and as such sometimes read Conservative Home. And so I was reading Conservative Home at the weekend, just to see what might be said. It's always interesting. No, it's not. No, it was worthwhile, actually. It was an article from Policy Exchange, which says, and I quote, "The amended offences would make criminal liability turn on a proof of serious disruption, which makes the meaning of minor hindrance and daily activities loom large." They felt that actually, of course there is a debate. You could, and I'm sure people were going to say, well, if you look at Lord Coker's amendment with the others who are supporting it, what does significant mean? What does this mean? What does that mean? Of course there are debates about what different words mean. But to pretend, as the government is doing, that by lowering the threshold and including words that they've included, that you get rid of that legal uncertainty, I say, my lords, that is not the case. Because instead of having a debate about serious, you will have a debate about minor. Yeah. And what that means. What is a hindrance? All of those sorts of debates will loom large, as the Conservative Home article suggested. Exactly so, although, of course, in my Amendment 1, as I've said, there would be a debate on the meaning of significant term. It sets the threshold higher, which is the point I'm trying to make through this amendment, not preventing protests that might be capable of hindering someone carrying out their daily activities. So the lower thresholds for serious disruption in Amendment 5 and others means that more than minor hindrance to the carrying out of daily activities or construction, maintenance works or other activities could result in police intervention and arrest. Wheelchair activists chaining their wheelchairs together in certain circumstances could cause more than a minor hindrance to daily activities. So stop someone shopping. Tree protests. I've had a look on various websites through the weekend. I've seen lots of different people supporting tree protests, where people have roped themselves or attached themselves to trees to prevent something happening. Who's to say those protests won't actually be affected by these amendments and by these new amendments in the bill? And I've seen fine, upstanding citizens, not just members of the Labour Party or the Communist Party, or socialist workers or other Liberal Democrats or Greens or others of similar ilk. Even Conservatives have joined those protests. Well, they're going to get a shock when they wake up and find their own government has said what you're doing is illegal, and the village green trees that have been there for 300 years outside the village pub are going, and there's nothing you can do about it because we've introduced protest measures, we've introduced amendments that actually mean that such protests will not able to be happening. Are we really saying in this chamber that the definition of serious is more than minor and not incompatible with Articles 10 and 11 of the European Convention? So at its heart is what does more than minor mean, particularly if applied to Clause 1. If I chained myself, as Liberty says, to a traffic light, and if that hindered 2 or more people from crossing the street to shop for 10 minutes, would that be more than minor? My lords, there is no legal certainty in what is meant by more than minor, nor indeed by what we mean by hinder. Remembering that serious disruption doesn't even have to happen for those offences to be committed. Turning to Amendments 48 and 49, the government's response... Yeah.
He spoke about legal certainty. Could he help the House on how a court is going to determine whether disruption is, quote, prolonged, unquote? If there's locking on, and if I'm unable to take my child to school, or unable to take my mother-in-law to hospital for an hour, 2 hours, 10 hours, is that prolonged?
Well, that's the point that I'm making. That what I'm saying is that there is, of course, going to be a debate about what various words mean. There is debate, and I've admitted it. I said to the Noble Lord and other Noble Lords that I used the term the debate about what significant means in certain situations. All I'm saying is that I want to set the threshold higher. I want the threshold to be at a level at which serious can be used rather than the minor level which the government seek to introduce, supported by other Noble Lords. And of course there'll be a debate, whether it's a debate on what I've put or a debate on minor or what hindrance means in certain situations. There will be a debate. But I think what this chamber should be saying to the courts, wherever that is, that what we actually mean by prolonged is that it doesn't just have to happen once. It doesn't just have to be a daily activity. It has to be something that impacts on the life of a community over more than once or twice. And that's what we're saying. And that's why I'm putting these amendments. I want the court to realise that when we, as this chamber, pass these, that we're saying serious means serious. And of course there'll be a debate about what that actually means. And it's like any instance, doesn't matter what law we pass, and Lord Panic has much more experience than I do in this. But of course, in the end, courts will have to determine what that means. And we'll come on to reasonable excuse in a minute. But I think the courts would want to know that this House has debated that and to try and say, and what I'm saying is that serious means more than minor, prolonged means more than daily. And of course, in the end, the court will have to determine that. But that is true, I say to Lord Panic, that is true whatever the wording we use in this bill. There will be a debate in the court as to what that actually means. And I want I want the court to debate what serious means. I want the court to debate what prolonged means. I don't want it to debate what minor means, because the threshold starts too low.
Grateful to the Noble Lord for giving way. I think he said just before the interruption by the Noble Lord, Lord Panic, that it wouldn't be necessary to prove serious disruption. Now, that cannot be right with respect. I hope it was a mistake on his part. I understand the amendment is to go before the definition of the offence, which includes the word serious disruption, which will have to be established. Is that correct?
Yes, of course. So if I gave the impression, then it was a mistake on my part. And of course, that's the whole point, essentially. Of course, there has to be serious disruption from my amendment. And what I think the debate, not the argument, the debate, as Lord Panic has just raised, is what we actually mean by determining what serious disruption means. But thank you for pointing that out. If I did say that was a mistake, and I'm grateful for the Noble Lord for pointing that out.
Could I interrupt for a moment? Forgive me. I'm just curious about this serious disruption, because quite honestly, if anyone has driven in London on the M4, on the M25, or through the streets of London, they will know what serious disruption is, because you get it every single day from people using their cars. So if we have any sort of confusion about what serious disruption is, that's it, traffic jams, all right? And we ought to lobby the government to stop traffic jams, perhaps, because they actually cause more delays to children getting to school, to ambulances, getting to hospital, and so on. So please, can we just understand that serious disruption is something we all experience every single day of our lives, and what we are talking about here is not really serious disruption. This is people who care about the future of humankind here in London and worldwide, and so could we take it a bit more seriously?
I sort of agree with my noble friend. I agree with her about the importance of the issues. I think everyone is taking it seriously in the chamber, and there is a legitimate debate going on as to where what serious disruption means. But my noble friend is right to point out that actually there are very serious, and we'll do that when we come to reasonable excuse in particular, there are very serious issues that we're discussing here. And just before I'm accused of being a hypocrite, I did drive here today, so I thought I'd better own up to that. Turning to Amendments 48 and 49, the government's response, we think, to slow walking, introduced at a very late stage, not in the Commons, not even at committee stage in the chamber, but here at report stage. My Lords, it has been our contention that existing legislation enforced robustly would deal with many of the problems we've seen. Indeed, as the Chief Constable, and no doubt will quote Chief Officers at each other, so let me start. Indeed, as the Chief Constable of Greater Manchester said in an article in the Daily Telegraph on the 12th of December 2022 entitled "Just Stop Oil Protesters Should Be Arrested Within Seconds," and argued as saying, I think fundamentally, if people obstruct the highway, they should be moved very quickly. In other words, arguing for greater use of obstruction rather than a whole range of new powers contained in Amendments 48 and 49. And we should remember that the existing law, whatever the rights and wrongs of this, have led to Extinction Rebellion calling off their action. And again, if we look at 48 Section 3, 49 Section 4, we have the same argument about hindering and or minor that I've just been through with respect to the meaning of serious disruption. In other words, the threshold for serious disruption is being lowered. My Lords, I believe all of us believe in the right to protest. And yes, sometimes we may get irritated if protest disrupts our lives. And clearly there have to be limits. But many of these amendments simply go too far. They will have a chilling effect on protests and protesters. It will undermine one of the fundamental freedoms we all enjoy, of standing up to injustice as we see it. It is a price we pay for our democracy, and any interference with these freedoms pose an unacceptable threat to the right of protest, which is a fundamental cornerstone of our rights and that of our democracy. And I beg to move Amendment 1.
Amendment proposed. Before Clause 1, a certain new clause is printed on the Marshal list in Amendment 1. And to remind the House that if this amendment is agreed to, can't call Amendments 5, 14 or 24 due to preemption. We also, on report stage, the laws are only allowed to speak once.
My Lords, I support Amendment 1, and no less strongly I oppose Amendment 5 in the proposed by Government and indeed by Lord Hope and one or two others. I never feel comfortable at the opposite end of the spectrum from my nobleman friend Lord Hope, but I trust that he feels at least as uncomfortable at the other end of the spectrum from me. My Lord, before commenting briefly on the actual language of these rival contentions, rival amendments, let me make what seems to me to be a critical preliminary point, and it's this. The meaning of serious disruption, assuming it's to be defined by one or other of these proposed amendments, is closely related to the concept and discussion and issue of reasonable excuse, and the rival proposed amendments as to that. Of course, I recognise that reasonable excuse comes into the next group, but it's important that it shouldn't be ignored at this stage. As your Lordships will readily understand, the lower the threshold is set for what constitutes serious disruption, then the less justification is there for narrowing down, let alone for excluding defence of reasonable excuse, or indeed for putting the burden of that defence on the accused. And so it becomes highly relevant as to what's decided in Group 1 when we get to Group 2. Of course, I acknowledge that the converse is true too. The lower the higher the threshold for what constitutes serious disruption, then the readier the House may be to look at shifting the burden, as the Act already does, on matters of that sort. My Lords, let me now turn briefly to the actual proposed definitions here. Is serious disruption here really to mean no more than substantial, which is, in other words, something merely more than to a minor degree, substantial interference with someone's daily activities as proposed by the government here? For example, merely somebody driving to the shops. Hindrance, which of course is the concept used in the proposed government amendment, is effectively just that. It's interference, it's inconvenience, it's really no more. So what weight, one asks, is given in the government's proposed definition to the word serious in the bill? Is it to be suggested that this is catered to sufficiently merely by the hindrance in the definition having to be, quote, more than to a minor degree? I would submit surely not. Now, I don't wish to damage the points made by the noble Lord Coker, and I would risk doing so if I were to go on at any great length. Surely here the preferable definition is that which is proposed in Amendment 1, substantial harm, as illustrated then in the amendment. It's that substantial harm, not merely interference, inconvenience, against which this legislation is directed, and indeed it's certainly only that which could possibly justify most of the repressive features of this bill. I therefore support Amendment 1.
Can I first address the remarks of the noble Lord Coker in his opening remarks? I have, as I've told the House before, considerable experience of public order policing, and my view is that the police have sufficient powers without any of the measures contained in this bill. And in fact, that is a view of many serving police officers who were interviewed by Her Majesty's Inspectorate of Constabulary Fire and Rescue Services, some of whom referred to the powers that currently exist as an armoury of powers to use in public order policing. And we've got even the protesters now, the Just Stop Oil protesters, saying that they're not going to protest in the way that they have before because too many of them are in prison. Well, if too many of them are in prison and they're not going to protest in the way that they have before, why do we need yet more powers for the police and more laws? I have amendments 3, 4, 12, 13, 22 and 23 in this group, which had nothing to do with the definition of serious disruption. So let me deal with these first. These amendments relate to the new offences of locking on, tunnelling and being present in a tunnel. The new offences include activity that is capable of causing serious disruption, even if no disruption whatsoever is caused. Another example of giving the police the power to intervene in anticipation that serious disruption may be caused before a process has even started. Amendments 3, 12 and 22 restrict the offences to activities that actually cause serious disruption. The new offences are not only committed by those who intend to cause serious disruption, but also extend to those who are reckless as to whether serious disruption may be caused, even if they have no intention of causing serious disruption. Amendments 4, 13 and 23 remove the reckless element. My Lords, Amendments 5, 14 and 24 and part of Amendment 50 and Amendment 51, as we have heard, relate to the definition of serious disruption. The Minister will no doubt cite the Commissioner of Police for the Metropolis in saying that the police would find it helpful if the definition of serious disruption was clearer. My Lords, Amendment 1, to which I...
My good man, a moment of your time. In 80 days, people will come, tens of thousands of people outside these gates, to demand an upgrade to our democracy, to confront the emergency in our climate and in nature.
Shut up.
As the suffragettes were seized, so too will we be.
Shut up.
All out.
Go in the House for 5 minutes, please.
Get up.
At your discretion.
Shut up. Shut up.
All out.
We're holding him down. We're trading. He's quiet now. If he opens his mouth again, I'll shut it again.
He's putting out
Now, madam, shut up.
He's completely quiet.
Sit down, please, shut up. Right, you out. 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 Please out. Madam, we've asked you nicely. Out now, please. Thank you. One at a time. Out. 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 Madam. Out. Out.
I need my two.
Out. Right, get out. Out. Out.
Look out.
Are you okay?
Out. And be asked nicely. 3 times.
Thank you. Thank you.
Well, a natural break in proceedings, because I'm now going on to talk about the definition of serious disruption. My Lords, Amendments 5, 14, 24 and part of Amendments 50 and 51, as we have heard, relate to the definition of serious disruption. The Minister will no doubt cite the Commissioner of Police for the Metropolis in saying that the police would find it helpful if the definition of serious disruption was clearer. My Lords, Amendment 1, to which I've added my name, provides greater clarity in relation to, with the best will in the world, what will ultimately be a judgment call by the police. A significant harm to persons, organisations or the life of community provides the clarity the police are seeking in ways that the alternative from the noble Lord and learned Lord Hope of Craighead does not, I respectfully suggest. It now even provides examples of what might constitute significant harm. Turning to the amendments in the name of the noble and learned Lord Hope of Craighead, the noble and learned Lord probably realised he had gone too far in his definition when the noble Lord the Minister signed it. My Lords, I am not a lawyer. I studied philosophy at university, not law. But I am not sure defining serious as being more than minor is that helpful, nor is it reasonable. Surely it begs the question, well, what is minor? Does the noble and learned Lord define minor as less than serious? Taking a common sense approach rather than a legal one, I thought the opposite of minor was serious, at opposite ends of a spectrum, in the sense that black is the opposite of white, not just the next level up. There are 50 shades of grey, apparently, between black and white. Anything lighter in tone than black is not white. To use another analogy, the definition of a serious injury is not anything more than a minor injury. I'm reminded of the story of an Oxford University student where the rule was that cats could be kept as pets but not dogs, so he called his dog Cat. Saying that serious disruption is anything more than minor does not make it serious, even if the noble and learned Lord wants to call it that. Of course, if the government wants to ban all protest that prevents or would hinder individuals from carrying out their daily activities to more than a minor degree, they should say that on the face of the bill, not to disguise the fact by saying anything more than minor is serious, that dark grey is white. More than a minor degree cannot reasonably be defined as serious. We will vote in support of Amendment 1 and, if necessary, against Amendments 5, 14 and 24. My Lords, Government Amendments 48 and 49 deserve additional mention over and above their adoption of the noble and learned Lord's definition of serious being anything more than minor. The police are asking for clarity. Let me quote from Amendment 48. Amongst other things, it says, subclause 4C, the senior officer reasonably believes that one of the conditions in subsection 1A to B is met in relation to the procession mentioned in paragraph A, and D, the senior police officer reasonably believes, one, in relation to a procession mentioned in paragraph B1, that one of the conditions in subsection 1A to B is met in relation to the procession. Or 2, in relation to an assembly mentioned in paragraph B2, that one of the conditions in section 14.1a to 1b is met in relation to the assembly. 3b, the senior police officer may a. give directions under subsection 1 in relation to 1. the procession mentioned in subsection 3a bracket small a, and 2. any procession mentioned in subsection 3a brackets b brackets 1 in relation to which the condition in subsection 3a brackets d brackets 1 is met. And B, give directions under section 14.1a in relation to any assembly mentioned in 3a brackets b brackets 2 in relation to which the condition in subsection 3a brackets d brackets 2 is met. I'm not sure that's the clarity the police are seeking. My Lords, these amendments go far beyond a 2-week definition of serious disruption. In considering whether a protest may result in serious disruption, the senior officer must have regard not just to the protest they are considering, but also to any other protest being held in the same area, even if they are organised by different people, involve different people, or even being held or intended to be held on the same day. The next thing the police will be telling protesters they cannot protest in central London because there have been a couple of protests this month already. What is more, the police can define what in the same area means. When the police were given powers to designate a limited area for a limited time for stop and search without suspicion under Section 44 of the Terrorism Act 2000, they designated the whole of London every day for years. There is nothing in these amendments to stop the Metropolitan Police, for example, from designating the whole of London as the area in which the cumulative impact of protests needs to be taken into account. The police are asking for clarity, so can the Minister please explain Amendment 48, subclause 2, brackets 2ZH, bracket A. What does all disruption to the life of the community, brackets 2, that may occur regardless of whether the procession is held? What does that mean? Disruption to a community even if a procession is not held. How can the life of a community be disrupted if a procession is not held? My Lords, these amendments give the police extraordinary power, new powers, to limit where, when and for how long marches and assemblies can take place, even if the protest is going to be peaceful, even if the protest itself is not going to cause serious disruption, but taken together with others in the area, even on a different day, may cause serious disruption. They also allow the police to define what area means. My Lords, these are yet more totally unjustified, unreasonable and excessive powers being given to a police service that no longer enjoys the confidence of large parts of society. We will vote against them.
My Lords, genuinely we saw a demonstration there in terms of an argument about what might constitute a serious or a minor disruption. And I feel as though we could argue for ages as to whether that was serious or minor. But one thing that I wanted to stress was why I support raising the threshold to the maximum and why I will be supporting these amendments. But what I wanted to ask the Minister and the Government in general was, what is this bill and these particular amendments, who are they aimed at? Too much of the bill in the justification we heard at committee and in newspaper articles since and statements that have been made by ministers focus on the tactics of Just Stop Oil and Extinction Rebellion. And it's undoubtedly the case that that wasn't what has not helped those of us trying to be liberal about the right to protest, was when those organisations themselves boasted that they wanted to maximise the serious disruption on people's lives to force and shock society into acting. So they didn't exactly help my side of the argument. and I'm certainly no fan of those tactics. But what I want to ask the government is, how on earth will this bill confine itself to only those protesters? That's really my point. When we were talking about serious disruption earlier, the noble Baroness Jones of Wilscombe made the point that those of us who get stuck in traffic jams know what serious disruption is, and she used the point to illustrate that she thinks there's too many cars driving on the roads. But actually, in London at the moment, in fact not just confined to London, but in London that I know of, there's lots of disputes going on at the moment around low traffic neighbourhoods, where what local people will tell you is that because the councils have put up blockages and bollards on local roads, often journeys that once took 15 minutes now take an hour and a half, and that goes against public consultations often. And the Mayor of Hackney last week boasted that he's going to block 75% of roads in Hackney, which I think is pretty serious disruption, and so do local people. The reason I've mentioned that is because there's now lots of protests being planned by local people against low traffic neighbourhoods. And when I was explaining to some people, including 2 Conservative councillors, about how this bill could be used against the protests about low traffic neighbourhoods, they said, don't be ridiculous, this bill is about stopping Extinction Rebellion. And I want the government to explain how they will confine this bill to what you say it's about. Actually, it's a bill that will affect anyone who wants to protest on anything, including Conservative councillors with Home Secretaries that won't necessarily be of the party sitting opposite in the future, will have enormous powers. So I just do not understand the logic of what you're trying to do, other than shooting yourself in the foot and confusing the members of the public who think it will only be directed at one particular type of protesters. It won't.
My Lords, I thought that the necessity for the Lord Speaker to retire for 5 minutes might be termed a serious disruption of the working of this House. But the point that I wanted to make quite shortly was the use of the phrase capable of causing, because according to the Amendment 48, it will be a serious senior police officer who will be deciding it. What on earth is he going to decide it on? It would be certainly easier with Just Oil or with Extinction Rebellion, but there are many other processions, as we know, and disturbances, particularly in London, but right round the country, and those he would not know about, where they were leading and what they would be like. How on earth is he to assess whether or not this is capable of causing disruption, serious disruption? It's an issue that I find very difficult to understand, and I hope that the noble Lord the Minister will explain what is really meant by a police officer deciding on causing capable of causing.
To follow the noble Lady Buckley's loss, and always a daunting privilege to follow the noble and learned Lord Eaton, or Lord Brown of Eaton under Hayward. My views on the necessity and desirability of this proposed anti-terror style legislation are no secret. But whether noble lords are for or against this bill, whether they are for or against its new offences, including thought crimes, stop and search powers, including without suspicion, and banning orders, including without conviction, all noble lords, it seems to me, must agree that the concept of serious disruption has been used throughout the bill as a justification and trigger for interferences with personal liberty. So serious disruption should be defined. However, His Majesty's government resisted any definition at all the way through the common stages of this bill, and in this House until this late stage. And my Lords, notwithstanding attempts by some of us on this side to provide a single overarching definition from very early on, at the committee stage. And despite even senior police requests for clarity. What a way to legislate. Bearing in mind that we are only here at all because of late amendments to last year's bill, the police etc. bill, which would have had this whole bill dropped into it again at a very late stage. So just over a week ago, my lords, via a Sunday afternoon number 10 press release, because number 10 press officers never rest on Sundays, with no amendment even attached to that press release, we learnt that there was to be some sort of definition so that, quote, police will not need to wait for disruption to take place, end quote. The actual government amendments and signatures to amendments by other noble lords were not published until about 24 hours later. So a whole media round the next morning, and before the conviction of Police Constable Carrick, a whole media round of debate around unpublished amendments. So I hope that in his remarks in a while, that the noble Lord the Minister might tell us when he first knew about this new approach, about the approach to have a definition at all, and why this new approach was heralded by press release rather than discussion in your Lordship's House. As for the substance of the issue, government amendments are confusingly piecemeal and set the bar too low before a number of intrusive police powers and vague criminal offences kick in. More than minor hindrance, my lords, is not serious disruption. More than minor is not serious enough. They cannot be serious. My lords, I face more than minor hindrance in congested London traffic every day, or even when walking through the doors and corridors of your Lordship's house at busy times. My lords, the definition of civil nuisance at English common law, involves substantial interference with the use and enjoyment of my property. My lords, should it really be harder to sue my neighbour for polluting my private land than it will be under the government's proposal to have my neighbour arrested for protesting against pollution in the public square? Obviously not. Or at least not in a country that prides both civil liberty and the ability of people to rub along together and even disagree well. Instead, the single, overarching and more rigorous Amendment 1 defines serious disruption as causing significant harm to persons, organisations or the life of the community. That is the overarching definition, and it includes, not only in the context of the significant delay in the delivery of goods and prolonged disruption of access to services set out in the 1986 Public Order Act. And to help the noble Lord panic, that concept of prolonged disruption is already in the 1986 Act, as amended by last year's the Police etc. Act. So that's not a new, novel concept. But we're really talking about significant harm instead of more than minor hindrance. And I urge all noble lords, whether they're for or against the bill in principle, to vote for that.
My lords, sorry.
Speak next because my amendments have been mentioned, and it's probably better that I explain what they are. Lords, I stress that these are my amendments. They're amendments 5, 14 and 24 in this group, and they substantially repeat amendments which I brought forward at committee. And there's a certain amount of revision of the words, but essentially I'm making the same point as I did at committee. And what they do is to seek to give effect to a recommendation by the Constitution Committee, of which I'm a member. And I'm most grateful to the noble Lord Fawkes, who is still, as I speak, a member of the Constitution Committee, for adding his name to these amendments. Now, Lords, the committee noted that the three clauses, and I'm talking now about locking on and tunnelling and being present in a tunnel, that's the target of my amendments, these particular offences. They use the word serious disruption to describe the nature of the conduct that this bill seeks to criminalise, and the committee noted that that could result in severe penalties, such as providing the basis for a serious disruption prevention order. And so they took the view that a definition should be provided. And on that issue, perhaps with the exception of the noble Lord Paddock, there is, I think, a wide measure of agreement across the House. A definition is needed because of the nature of these offences and the consequences that follow from them. Now, Lords, I'm
very grateful to the noble Lord. Just to clarify, I support Amendment 1 wholeheartedly, which is a definition of serious disruption.
There is agreement that a definition is needed because of the nature of the crime and the consequences that follow from it. Now, my Lords, the committee noted, of course, that a definition was given in sections 73 and 74 of the Police Crime Sentencing and Courts Act 2022, to which the noble Baroness Chakrabarti has referred. And these are sections that deal with the imposition of conditions on public processions and public assemblies. Now, the amendment in the name of the noble Lord Coker seeks to adopt the same definition for the purposes of this bill. But the committee...
Sorry to be a more than minor hindrance, or hopefully a minor hindrance to the noble and learned Lord, but it does not replicate that definition. The concept of prolonged disruption is a tiny part of the definition, but Lord Coker's, my noble friend Lord Coker's Amendment 1 does not replicate the definition in Section 73 of the 1986 Act. The new overarching principle that we introduce with Amendment 1 is significant harm to persons, organisations or the life of the community, and that is not in the 1986 Act. That is not the provision that's limited in the 86 Act to processions or indeed assemblies.
Well, I'm very grateful to Noble Baroness, and I accept, of course, her correction. Of course, the catalogue that follows is very much the catalogue that you see in the 2022 Act, and it was that took our attention in committee. And the view we took was that really that definition was not suitable for this use in this bill because of locking on and especially tunnelling. And what we said was that the definition should be tailored to the very different offences of which we're concerned in this bill, and it recommended that the meaning of the phrase should be clarified in a proportionate way, for a reason I'll come back to, because the noble Lord Brown of Eton under Haywood mentioned that point, in a proportionate way in relation to each offence. And that, my lords, is what my amendments seek to do, and I suggest that they are more in keeping with what the Constitution Committee was contemplating than the noble Lord Coker's amendment. My lords, what I've tried to do is to provide definitions that are tailored to each of these three offences, which are short, simple, proportionate, and easy to understand. And this is a situation, after all, where guidance is needed for use by all those to whom the offences are addressed. And that audience includes, of course, members of the public who wish to exercise their freedom to protest, the police who have to deal with these activities, and the magistrates before whom most of any prosecutions under these clauses will be tried. Now, my lords, at the end of my speech in committee, my aim was to invite the noble Lord the Minister and his bill team to recognise the importance of the issue, and if my amendments were not acceptable, to come up with a more suitable but just as effective form of words. Now, my lords, as you can imagine, as we so often issue invitations of this kind, these words were uttered more in hope than in expectation. So on this occasion, my hope, rather to my surprise, was realised when the bill team began to take an interest in what I was seeking to do. And I have to say that I am grateful to them and to the ministers in the other place and in this House for the discussions which then followed, which helped me to improve and finalise my wording. Lords, I do not cannot claim that I've found an absolutely perfect solution, but I think that what I have done is achieve the best that can be done, and certainly very much better than the alternative which is before your lordships. Let us look at tunnelling, for example, and this, after all, is meant to be an overarching definition to supply the needs of 3 offences. One in locking on, the other 2 are tunnelling. And what does the amendment really tell us about tunnelling and what the police and others should be looking at? They tell us that serious disruption means disruption causing significant harm to persons, organisations, or the life of the community. And I think the closest this comes to the effect of tunnelling, thinking particularly of HS2, is the words harm to organisations. But the problem is it doesn't really say what that means, and that's the question. That guidance is missing. It gets no help at all from the long catalogue of examples of the kind of things that may result from processions and assemblies. And, my lords, I have to confess, as a lawyer, I'm concerned in the proper drafting of things that are being produced by this House as definitions. They should really do the job which they're designed to do, of providing definitions that are appropriate for the language you find elsewhere in the particular bill. So my amendment, to which the Noble Lord Anderson has very kindly added his name in the case of tunnelling, refers instead to preventing or hindering, to no more than a minor degree, any construction or maintenance works or other activities that are being performed on the ground above the tunnel or in its vicinity. What my amendment does is direct attention to what is really happening on the ground, and I do believe that is very much more helpful than the language in Amendment number 1 that is before us. Now, my lords, of course, I recognise that I'm using the words to more than a minor degree, whereas the Noble Lord's amendment uses the words causing significant harm, and it has been suggested that this is a lower threshold. But that really is to misunderstand the words that I've used. The key word in my phrase, to more than a minor degree, is the word more. And my point is that the disruption becomes significant when it is more than minor. What is more than minor is significant. And what everyone wants to know in a situation where the disruption is likely to continue for some time, which is the case of these 3 offences, is at what point, when does it reach the stage when it is appropriate that the police should intervene because the disruption has become significant. And my point is that it reaches that stage when it is more than minor. Now, my lords, of course, we're dealing with words about which we can argue, and I notice Mrs. Baroness Chakrabarti shaking her head, because, of course, the word significant...
I'm very grateful to the Noble and Learned Lord. He says more than minor is significant. So would he say that more than minor is not serious, it's significant?
Which we're dealing with, which is significant, is the word in the amendment. Amendment number 1, and it's defining, of course, serious disruption. But we're trying to find words which are defining what we mean by serious disruption in the case of these 3 offences, which is my particular point. And I come back to the point that the important word is the word more, because I'm trying to establish the point, the threshold at which it's right that the police should intervene. And the problem with the word significant, of course, is that it can mean different things to different people in different contexts. I give way.
To the Noble and Learned Lord, I think perhaps the difference between us is that he's suggesting that there's a binary. There's minor and then there's significant, and therefore anything more than minor must be significant, or forget significant, serious. And I think to understand the intention behind our amendment, one needs to think about significant harm. Harm as in damage. And harm and damage, and significant harm and damage, are well understood in the law, as the noble and learned Lord understands. And as for his concerns about the long list that is a replication of provisions previously in the 1986 Act for assemblies and processions, just to reiterate, those are just examples. They're a non-exhaustive list of examples. The crucial part of our definition is significant harm. And significant harm, I think, an ordinary person on the street would understand as more serious than minor hindrance, or 1 iota more than a minor hindrance.
To identify the threshold at which one reaches a point where, on my approach, one moves beyond something that is a minor disturbance to something that becomes significant. That's why I use the word more, and that is the point at which I suggest it is right, given these particular offences, that the police should then intervene. Because I ask the question, once one reaches that point, why should in the case of the tunnelling, go on and on? Because people are arguing about whether we've reached the stage, or whether the harm that has been caused is significant, without the further guidance of being directed to the point at which it becomes significant. The problem with these words, as the noble Baroness really is addressing to me, is that they can mean a range of things within the compass of the word significant. And I'm trying to direct attention to the particular offences and the particular consequences that are following from the activities that are being carried on. And that's why I suggest that the word more is the most important and significant part in my formula. My Lords, as for locking on, the other of the three offences, I don't have a long catalogue of things that may be affected. There's always a risk that something might be missed out. So I've tried to capture what is put at risk by the omnibus words, their daily activities. But here again, the threshold that I'm seeking to identify is to be found in the words more than a minor degree, for the reasons I've explained. And again, the question is, why should the police wait any longer once that threshold is reached? Now, my Lords, I come back to the point that the noble and Lord Brown of Eton Hayward was mentioning about proportionality and the reasonable excuse point, because proportionality is very important. The threshold has to be put into the right place. And that's because we do need to consider at what point the interference with the conventional rights of freedom of expression and freedom of assembly and association becomes disproportionate. Now, in its judgment in the recent Northern Ireland Abortion Services case, delivered last December, the Supreme Court said, and I'm quoting from paragraph 34, "It is possible for a general legislative measure in itself to ensure that its application in individual circumstances will meet the requirements of proportionality without any need for the evaluation of proportionality in the individual case." In other words, there is then no issue for a jury to consider or a magistrate to address his or her mind to. In other words, it will have been sufficiently addressed if the issue identified in the legislation is in the right place. And as to that is whether that is so, I think some guidance can be found in a decision of the Grand Chamber of the Strasbourg Court in a Lithuanian case called Kudrevicius in 2015. Now, my Lords, that was a case about a demonstration by farmers, of which there are a number have happened in recent years. They had gathered in a number of groups to block the traffic on a number of public highways. The court said that in that case, the disruption of the traffic that resulted could not be described as a side effect of a meeting in a public place, but rather as a result of intentional action by the farmers. In other words, they were intending to disrupt the highway. Physical conduct, purposely obstructing traffic and the ordinary course of life in order to seriously disrupt the activities of others, the court said, is not at the core of the right to freedom of assembly. That in itself, however, was not enough to remove their participation entirely from the scope of the protection. So that's the background for what the court then decided. But they did say that contracting states, and that includes ourselves, enjoy a wide margin of appreciation in their taking of measures to restrict such conduct. The farmers' intentional, serious disruption of the highways to a more significant extent than that caused by the normal exercise of the right of peaceful assembly in a public place was enough to enable the court to conclude that the criminal sanction which was imposed there was not disproportionate. So that's an example of a case which was across the border from being a side effect of what was happening to something that was a deliberate obstruction of traffic, which is what locking on is all about, and a deliberate interruption of, let's just say, the HS2 development, which is what tunnelling is all about. And my approach also has the support of a decision by the Divisional Court in March last year in a case called Kukurian. That was a case about tunnelling. It affected only a small part of the project, HS2 project, lasted only for 2.5 days, and the cost of removal was less than £200,000. But the prosecution for aggravated trespass was upheld as not amounting to a disproportionate interference with the protesters' rights. Now, Lords, I'm sorry to weary your Lordships with those references, but having looked at those and other case law, I do believe that the position that I've adopted in these amendments it does strike a proportionate, the correct balance for a proportionate treatment of these rights that we're talking about. Lord, of course, I hope that the Noble Lord Coke will not press his amendment, although no doubt he will feel he should do that. But because I do believe, really, it's not fit for purpose. It's not right to introduce a general definition of that kind, which is perhaps all right for one of 3 offences, but really is completely out of place for the other 2. It's not good legislation. In other words, we try in this House to improve legislation, and with the greatest respect to the Noble Lord, I don't think that amendment improves it. On the contrary, I suggest that my amendments do improve it, and when the time comes, if I have the opportunity to do so, I will be seeking to test the opinion of the House.
I do admire the Noble Lord Hope for trying to convince us. I rise to speak now because I support and have signed Amendment 1. And I can't argue the law, I can't argue how many angels dance on the head of a pin, but I can question the politics. And my concern about the politics of the whole bill is that the government is seeking to, words have been used as regressive and repressive. This is nasty legislation. And you have to ask, is it appropriate for a few dozen protesters? This heavy-handed legislation, is it appropriate for that number of people who do occasionally disrupt our lives? And I would argue it's not, and it's almost as if this legislation is designed instead, perhaps, to prevent millions of people from protesting, because the government knows it has lost the confidence of the public here in Britain. And in a recent poll, 2/3 of people thought the government was corrupt. Now that sort of suggests that any legislation this government tries to bring in is possibly not very well designed for the majority of people here in Britain. You're giving powers to the police, very heavy powers, and we've already seen the public doesn't trust the police anyway, and you're giving more powers to ministers, and we don't trust ministers. So it is very heavy legislation. And I'm worried that what you're doing actually is bringing legislation that when there are general strikes and when there are hundreds of thousands of people out on the streets actually protesting about the collapsing and soon to be privatised health system, or the fact that everybody's pay is getting squeezed apart from the bankers and the wealthy. That's what I worry about, that you're actually bringing in these laws for far more people than just the protesters. And quite honestly, Insulate Britain, who would not agree with Insulate Britain? It's the smartest thing we can possibly do if we're worried about our energy crisis. And so it seems to me that the government isn't really focused on the protests that we've had so far. They're actually getting focused on protests that we might have in the future. And we now are going to vote very soon on whether or not to declare a protest is illegal if it disrupts somebody. The whole point of protest is that it disrupts life to some point, so that you notice it, so that you start debating it, so that it gets reported in the newspapers. It's incredibly important, in a sense, that protest is disruptive. And I did hear the Noble Lord Hope saying that Amendment 1 wasn't suitable, but I think I have taken advice from lawyers, and I think it is entirely suitable, so I will be voting for it. My big concern here in this House is that we have a government that is simply out of control, and they talk about protesters being out of control, but I think it's the government that's out of control.
The Constitution Committee, as the Noble and Learned Lord Hope said, considered that a definition of serious disruption would be useful. And I think there's a measure of agreement around the House that it would be, where the debate exists as to how best to define serious disruption. And the amendment by the Noble and Learned Lord Hope, to which I've added my name, is an attempt to provide that clarification. And I can well imagine a court asking itself the question, well, what is a serious disruption? And looking to see if Parliament has given any help, and none for the moment is provided. So that I welcome the fact, albeit somewhat at the 11th hour, the government has accepted that a definition will be useful. The Coker Amendment, if I may call it that, it has the support of others who have already spoken to it, places the bar high. When combined with the necessity of proving not only intention or recklessness on behalf of the putative offender, but also the absence of a reasonable excuse, and that, if the amendment in the name of Baroness Chakrabarti is accepted, is a prerequisite before you get to the other elements in the offence. It seems to me, with all these combined, it would be very difficult, almost impossible to establish that an offence had been committed. Now, that may well be the underlying purpose behind this combination of amendments. The opposition parties may not approve of this legislation, and if they cannot get rid of it altogether, they may wish to emasculate it to such an extent that practically it cannot be relied upon. And that's a perfectly tenable point of view, but not one that I share, nor do I think do the general public, having seen the effect of some recent demonstrations. The definition in the name of the Noble and Learned Lord Hope does not place the bar as high as the Coker Amendment. It provides that an act that will result in or be capable of causing serious disruption if it prevents or would hinder to more than a minor degree, and he emphasised to more than a minor degree, the individuals or the organisations from carrying out their daily activities. Now, clearly that would exclude mere inconvenience, but it would include disrupting, and that's an important word, my lords, people from going to work, going to hospital, going to a funeral, going to a sporting event, taking a child to school, or other daily activities. If they were only inconvenienced to a minor degree, then that would not be a serious disruption. But the Hope Amendment would, I suggest, be a useful guide to courts in determining what amounts to a serious disruption. If it is suggested that it sets the bar too low, my lords, bear in mind those additional requirements. So mere accidental interference is not enough. And bear in mind, too, how these are bespoke amendments to deal with locking on or tunnelling. They're not just general, vague attempts to raise the bar to a particular level. I also think that opposition parties might wish to bear in mind what the Labour Party's Shadow Justice Secretary said in this connection, and I quote, "Our brave emergency services are being held up from helping those in distress, and lives have been put at risk. On top of that, the public has been stopped from going about their everyday business." End quote. I don't suppose the opposition would wish to dissociate themselves from that, and it seems entirely consistent with the Hope amendments in relation to serious disruption. And, when we come to it, reasonable excuse. Now, of course, I entirely accept that the right to protest is fundamental, and we must, as citizens, be prepared to put up with inconvenience caused by those exercising this important democratic right. We may find it noisy and annoying, and depending on how much we sympathise with the cause, even very annoying. But that would not be enough to be a serious disruption. It must be something more than annoying, but less than the very high hurdle which must be surmounted on the wording of the Coker Amendment. I think ultimately it may come down to whether or not your lordships consider that the right to protest is so fundamental that it must trump the rights of ordinary people going about their everyday lives. It is a difficult balance to strike, but though I respect profoundly the right to protest and have sympathy for many of the relevant causes, it seems to me that one has to counterbalance the rights of others to go about their life. These rights are entitled to protection too, and this amendment attempts to achieve a balance between those respective rights.
My Lords, I'm also glad that your Lordship's House is trying to explain, for the benefit of protesters and police, what is meant by serious disruption, even if we are not finding it very easy. I'd like to start with the new tunnelling offences in clauses 3 and 4, which, as I said in committee, in support of the consistent approach of the noble and learned Lord Hope, are in a very particular category. The key point, recognised in Amendments 14 and 24, is that the disruption liable to be caused by tunnelling is not to the general public, but to the construction or maintenance works. So delays to the delivery of time-sensitive products and prolonged disruption of access to a rather specific range of goods and services, as specified in the noble Lord Coker's Amendment 1, are not really to the point. The one-size-fits-all approach in Amendment 1 is neither designed for nor appropriate to the tunnelling offences. I would add that to require disruption to be more than minor in order to constitute the new offences seems to me quite sufficiently generous to tunnellers who are seeking to disrupt those engaged in lawfully authorised works. That is why I put my name to Amendments 14 and 24, and why I shall support them if they are put to a vote. My Lords, the arguments are more finely balanced in relation to Amendment 5. The locking on offence, as the noble Lord Coker has said, can be constituted by a remarkably wide range of actions. I am wary of a test that is too easy to satisfy, bearing in mind that serious disruption, or the prospect of serious disruption, is the trigger for the no suspicion stop and search power, and for SDPOs, the whole existence of which are controversial, at least to me. But I take comfort from the fact that, as the noble and learned Lord Hope has explained, hindrance to the public needs to be significant before it can meet the test of being more than minor. And indeed, significant, not, I think, substantial, is the very word used in Amendment 1 when it refers not only to significant harm, but to significant delay. The recent policy exchange briefing to which the noble Lord Coker referred complains that the more than minor test may be interpreted in the light of the Strasbourg case law so as to maximise the space for protest. I agree that it will have to be interpreted in conformity with the ECHR. Policy Exchange seems dismayed by that. I am rather encouraged by it. When Lord Hope's definition is criticised from one side for being too easily satisfied and from the other for being too difficult to satisfy, perhaps it is not too wide of the mark, even in this more sensitive context. But my main point is that whatever view noble lords may take of Amendment 5, the case for Amendments 14 and 24 is a strong one. I hope we will have the chance to vote for them.
Can I just, before my friend sits down, can I ask him whether he would agree that there is no particular reason why Amendment 1, although plainly it would preempt Amendment 5, should preempt Amendments 14 and 24?
Yes, it does. That's a direction to the Chair. Yes.
Oh.
Yes,
I believe the Chair so directed at the outset of this debate, but I'll be corrected if I'm wrong about that.
My Lord, I'm not asking, and not from a musical perspective, whether if we change the word minor, more than minor, to major, we might not make some progress, because surely that's what it means.
I'm very conscious that an expert musician will certainly know the difference between minor and major. I take refuge in the fact that there is no such amendment before us, so perhaps I don't need to answer that today.
Lords, the right to protest in a democracy is of central importance, but I cannot see that there is much of a right to glue yourself to another person or object in order to disrupt the daily lives of other people. And that's what we're talking about here. There are many ways of protesting in our democracy without locking yourself on, without disrupting the lives of others. And the conduct with which these clauses is concerned is very often, as Baroness Jones accepted, for the very purpose of disrupting the lives of others. I myself do not think that such conduct should be unlawful, as Amendment 1 proposes, only if it causes prolonged disruption, preventing people from going to work, taking their children to school, taking relatives to hospital, should be unlawful. That is, as far as I can see, more than minor and sufficiently strong to outweigh the interest of the protesters, as the cases cited by Lord Hope demonstrate. There's one further point that I suggest the House bears in mind. There is a danger when we consider all of these amendments that we consider them by reference to protest with which we may sympathise, maybe environmental causes. But the protest may also be by those whose causes are far less attractive, far more damaging to a democratic society. And such protesters also may decide to lock on, and the law does need to deter and to penalise them.
I rise just to remind us, I think, in a way, why we got here, really. I mean, first of all, there have been a series of events over the last few years where people have criticised the police and CPS and the government for not intervening when people have been seriously disrupted. That's why I think we're having this debate. We could go through various cases, whether it be Heathrow, the M25, taxis around Parliament Square, when they were kind enough to leave a lane around the outside, by their decision, a point I will come back to. And so, therefore, people have complained the police have been not intervening. And one of the reasons the police have not been intervening is because the usual offence that they rely upon, which is obstruction of the highway, which is a very simple, absolute offence, no intent to be proved. All that had to happen was there was an obstruction of the highway. There's a Supreme Court in this country has had to consider that simple offence and concluded that there was more to consider than just was the highway blocked. It said, was there an alternative route? Could other action have been taken by the police? Lots of more really talking about intent in what is really a very simple offence, because usually the penalty is a fine, very rarely would imprisonment be imposed. And the second reason it's having to be considered is because people have got angry, some members of the public have got angry and started to take action themselves when the police have not, which is always dangerous. I think we can all recall we've seen films of people on the tube where somebody sat on the top of a tube carriage and the crowd pulled him off. Very dangerous for everybody involved. Terrible situation, shouldn't happen. We've seen cases where the motorways have been blocked and the people at the front start to intervene because they're fed up of waiting and it appears nobody's going to do anything. And in any case, what? Of course.
Certainly at committee, the point was made, and I wondered what you felt about it, that this was a crisis of policing with the police not enacting laws that we already have. And it is entirely fair that the public have got frustrated and demanded something should be done. But the question I would ask you is, if it's the case that the police are uncertain what to do with a huge armoury of public order offences that could be used, and sometimes are used, but in a fairly arbitrary fashion, why giving them more powers and more laws will solve the problem of them not using the ones they've got already? And that actually will disillusion the public even more with the whole process of criminal justice.
Well, Baroness makes a good point, and I was going to come on to a point that she made, but the point that's being made by the police is, if there's a lack of precision around something as simple as obstructing the highway, can you help us? People have alluded to the fact that the police have asked for help, and this is one of the things that Parliament can do, just to explain more clearly how obstruction can be a protest that is beyond the criminal boundary, particularly where protest and political motives are involved, because generally the police will try not to get involved in that, so they are seeking help, which is why I think they're asking for more legislation rather than less, although generally I think they would say that they don't need any more legislation. Lord Coker explained very well, and his amendment explains why he would like to approach this in a different way. The problem I have with this amendment is it talks about a prolonged, and Lord Panic referred to this, a prolonged disruption. And I particularly don't like it when it's talking about health. What if somebody's having a heart attack or a very serious issue, a medical issue, that requires minutes rather than hours or days in some cases?
To the noble lord for giving way. Just to be clear one more time, the prolonged disruption is just an example. So you do not have to have a prolonged disruption for the significant harm to be caused to a person, an organisation, or the life of the community. And I cannot think of a more significant harm than a person with a heart attack not being able to be transported in an ambulance.
That's what it says, is prolonged. And, well, if I may just continue with it. And secondly, is that who's going to decide? Because one of the proposals, and Lord Paddock made this point, people may have lost some confidence in the police for reasons that we understand. But the alternative appears to be that we leave it in the hands of the protesters to decide how long they'll stay. And I find that unacceptable. If the state's going to have a view on these things, then sure, it's for the state to decide, not for the protest to decide. Of course they're going to have a view, and of course they may have a different view. But they have to take the consequence if they get that line wrong. And at the moment, that isn't what's happening. Baroness Jones made the point that we can all be disrupted. And she's often made this point, and I've often disagreed with her, that we're always disrupted every day, certainly in London, not the rest of the country, frankly, but certainly in London, by congestion. And therefore, why should we criminalise protest that only does the same thing, if I'm fairly representing her argument? Nearly. But pollution kills people. But we're not trying to legalise unlawful killing. And if you pursued that argument to its logical extent, I'm afraid that's what I see could be the only logical extent. I do not accept that somebody intentionally blocking someone's path is exactly the same as someone who is suffering the consequences of congestion. But I suspect you're going to say something.
Thank you to the noble lord for sitting down. In a disruption, people can turn their engines off. What they do in traffic is to keep them running.
Sorry, because I was looking at my note, I missed that. Would it be terrible to repeat it so that I could properly respond? Sorry.
It's so profound. What I said was, when there is disruption, people know it's going to last some time, and so they can turn their engines off. What happens in traffic is that people leave their engines running, which, of course, is highly polluting, as the noble lord says.
Okay. But the protesters could leave. It's in their gift, I think. So...
The Met Police, after the disruption on the motorways into London, they actually put out a tweet asking people to report instances of where perhaps they hadn't been able to get their children to school or medical emergencies or whatever. The stream of replies after that tweet from the Met Police was nothing to do with people objecting to the disruption. They were actually supporting the action. So the Met Police might have got that slightly wrong.
So my final point is only this, is that although I can't support Lord Coker's amendment for the reason that I explained, I hope, I do support Lord Hope's, but I think the challenge that Lord Paddock made, which is that minor sounds intuitively contentious when referring to something that's serious, is an unusual bar to define something as. And I think probably, and Lord Hope I think acknowledged this, is that there may be more work to do around that.
I'm grateful to the Lord for giving way. I did stress that the word more is the important word, and I quite agree. The word minor does raise issues, but the more point is absolutely crucial to an understanding of my formula.
And I accept Lord Hope's point, and of course I would never tangle with any lawyer, but I'm just saying at an intuitive level that even to define something as more than minor may be a concern, and there may be a different form of words. In fact, I thought the form of words that Lord Hope, when he spoke, found might have been something that people might have been able to group around, whether it's the word significant or, as Lord Berkeley said, major, I'm not sure. But it may be that we're broadly agreeing that serious disruption is not okay. That's why I hear people saying, whether in any of the amendments, what we're struggling to define is exactly the point to define it. And finally, not to leave the police with too much problems in terms of intent, recklessness, reasonable excuse, because if you have a very simple definition of an offence and then have to start worrying about all the intent and recklessness, it will get almost impossible, I suspect. And we'll be back to where we started, which would be a concern.
My Lords, just at this point, could I just remind the House on the rules of debate on report, which say that on report no member may speak more than once to an amendment except the mover of the amendment, and intervening repeatedly on other members, which isn't really in keeping with rules of debate on report. I would just gently remind the House of that. Thank you.
My Lords, during the Bill's second reading and committee stage, there was much discussion on the meaning of serious disruption, and many noble Lords spoke to the need of providing a clear definition on the face of the Bill. My Lords, I'd like to thank all noble Lords who've participated in what has been a fascinating debate on this subject. At second reading, I agreed with many of the comments made by your Lordships and committed to take the matter away. And so what we're debating today is a matter of thresholds, as all noble Lords who've spoken have noted. And the debate is not about whether these measures ban protest. Quite simply, they do not. And I'd like to thank the noble Lord Coker for his comments emphasising that fact. What we are trying to ascertain is the point to which protesters can disrupt the lives of the general public. And the government position is clear. We are on the side of the public. I'd like to thank the noble Lord Coker for tabling his amendment, which provides a definition of serious disruption for offences within the bill. I agree with the purpose of the noble Lord's amendment, but do not believe that the threshold is appropriate. The government wants to protect the rights of the public to go about their daily lives without let or hindrance. I do not believe that the noble Lord's amendment supports this aim, therefore I cannot support it. My Lords, I make no secret of what the government is trying to do. We are listening to the public, and we are listening to the public who are fed up with seeing day after day protesters blocking roads. They make children late for school, they make people miss hospital appointments, they make small businesses struggle. Any change in law must address this, and I do not believe the noble Lord's proposed threshold does. In this vein, I'd like to turn to amendments tabled by the noble and learned Lord Hope of Craighead, which also provide a definition of serious disruption, but for the specific offences of locking on, tunnelling, and causing disruption by being present in a tunnel. The noble and learned Lord's amendments follow the judgment handed down by the Court of Appeal following the Colston statue case. The court found that the right to protest does not extend to acts of criminal damage that are violent or where the damage is more than a minor or trivial degree. And I quote, "We cannot conceive that the Convention could be used to protect from prosecution and conviction those who damage private property to any degree that is other than trivial." We agree with the judiciary and believe that this threshold should be consistent across the statute book. Although the court concerned itself with the matter of damage to private property, the same principles apply to obstructing the public from enjoying their right to go about their business without hindrance. That's why the government is supporting the noble and learned Lord's amendments, and I'm very pleased that we were able to surprise him in this regard. They provide a threshold for serious disruption that is rooted in case law. I thank the noble and learned Lord for tabling this amendment and indeed for explaining it in such a detailed and precise way. But the amendment provides both clarity to the law and a threshold that addresses the public's frustration with disruptive protests. My Lords, I will now speak to the government's amendments 48 and 49. The Commissioner of the Metropolitan Police Service has asked for further legislative clarity on the police powers to manage public processions and assemblies. These powers are conferred by Section 12 of the Public Order Act of 1986 for processions and Section 14 for assemblies. They allow the police to place reasonable and necessary conditions on protests to prevent specific harms from occurring. One of these harms is serious disruption to the life of the community. And these two amendments provide clarity to this phrase for both Sections 12 and 14. The noble Lord Paddick was quite right in anticipating that I would be quoting Sir Mark Rowley. He said, "I welcome the government's proposal to introduce a legal definition of serious disruption and reasonable excuse.
In practical terms, Parliament providing such clarity will create a clearer line for police to enforce when protests impact upon others who simply wish to go about their lawful business. These amendments, supported by the police, prioritise the rights of the law-abiding majority. First, it carries over the noble and learned Lord Hope's definition of serious disruption. Second, it defines the meaning of community. Third, the police may consider the absolute impact of the disruption caused to the public. Fourth, it allows the police to consider the cumulative disruption caused by protests. And finally, it allows the officer responsible for managing the protest to place conditions on more than one connected procession or assembly. And in answer to the noble and learned Lord Paddock's comments that these are too complicated, the Home Office will work closely with the NPCC and the College of Policing to ensure that appropriate guidance and training is developed. Mirroring Lord Hope's definition will provide consistency across the statute book. And as I've said, this is welcomed by the police. And I would like to point out that the definition specifies that the disruption is caused by physical means only. My Lords, on Lord Coker raising the policy exchange paper, the use of minor in the definition, these amendments protect the daily activities of the public, and it is clear that the public are fed up with the disruption caused by protesters, and that is what these amendments address. Many protests that do not disrupt the lives of others occur on a regular basis, and the noble Lord Hogan Howe made, I thought, a very, very good point, that we should not be allowing the protesters themselves to determine the scale of the disruption. Many protesters are able to express themselves and place pressure for change without blocking roads. My Lords, currently the term community is undefined. The police should be able to use their powers to protect anyone who is detrimentally impacted by serious disruption from protests, not just those who live, work or access amenities where the protest occurs. The police must consider the absolute disruption caused to the public as opposed to the disruption relative to what is typical for this area. This measure will give officers the confidence that they can use to respond to disruptive protests, even in areas routinely subject to spontaneous disruption, such as traffic jams. To prioritise the rights of the public, the amendment allows the police to consider the cumulative impact of protests and separate protests. It is wrong that the public must repeatedly put up with disruptive protests, in part because each time there's a new protest, the police must consider the level of disruption afresh, and in isolation from what has previously happened and what may be planned. If multiple protests cumulatively ruin the daily activities of a community, then they must be considered collectively. And following from this, if the police are to manage the collective impact of protests, they must be able to apply the conditions on separate but connected protests. For example, a large protest campaign made up of multiple small protests that disrupt a large area should be subject to blanket conditions. Allowing the police to consider the cumulative impact of protests, but requiring them to manage each individually unnecessarily complicates the operational response. So collectively, these measures will allow the police to protect the public from the disruptive minority who use tactics such as blocking roads and slow walks. The public are clear that they want the police to protect them from these tactics, and in turn the police have asked for clarity in law to confidently and quickly take action and make arrests where appropriate. The government has listened to both, and I hope this House does the same and supports the amendment. Turning to the amendments tabled by the noble Lord Paddock, which I will speak to collectively. These measures do two things to the locking on and tunnelling offences. First, they lower the threshold of the offence so that acts that are capable of causing serious disruption are not in scope. And second, they alter the mens rea so that only intentional acts and not reckless ones are in scope of the offence. It's clear that the public do not want to see police officers sit by while criminal protesters disrupt their lives. Lowering the threshold would mean that the police will have to do so. So why should an officer stand by and watch somebody lock on or dig a tunnel that is clearly going to cause serious disruption to the public? And as for the mens rea, as I've said already, the government is concerned with the disruption caused to the public. Whether it is caused recklessly or intentionally, that does not matter. What matters is the impact it has on people's daily lives. So for all those reasons, I encourage all noble lords to support the noble and learned Lord Hope's and the government's amendments and reject the others.
Could I ask the noble Lord the Minister to deal with the issue of be capable of causing, as opposed to actual disruption?
Well, I would say to the noble and learned Baroness that I think I rather did deal with that when it was caused, when I was talking a little bit about the tunnelling and locking on offences. why should the officer stand by and watch somebody lock on or dig a tunnel that is clearly going to cause or be capable of causing serious disruption to the public? And I think certainly in the terms of tunnelling, that's very, very clear.
My Lords, can I thank all noble Lords who've participated in this, what I think has been a really interesting and thoughtful debate. Can I thank the Minister for his response? I don't want to go through every single contribution, so I don't wish to be rude to anybody who I don't respond to or point out, but I just wanted to make and reinforce a couple of particular points. In answer to Lord Fawkes, I totally agree with him, and just to repeat that the attempt by this chamber to define serious disruption on the face of the bill, as the Constitution Committee asked it to do, I think is a really important step forward. And I think it's a really important thing to try to do. The debate between us is where we set the threshold and where we how we define serious disruption. And perhaps this debate should have taken place within this bill a few months ago, but it's taking place now and is particularly, I think, important. I wanted to just, before coming on to a couple of points about the amendments, I do worry, and I think Baroness Fox was quite right to point out, that one gets the impression that the government have faced protests that all of us have been annoyed about, frustrated about, angry about. And what we see both initially with some of this, but in the amendments that have just been brought forward, a government that actually, in my view, wants to be seen to be doing something about it. And the Prime Minister's announcement 2 weeks ago was a typical example. I say this to the Minister, I don't believe the Home Office would have known anything about that. I know from what I know, the Prime Minister thought, I'm not having all this. This stopped the oil, Extinction Rebellion, people moaning about protesters being out of control. I'm not having it. We need to be doing something. Put it out there that we're going to introduce new amendments to the Public Order Bill at report stage in the House of Lords and ring the Home Office up in the morning and tell them we're doing it. That's exactly what happened. In my view, and I'll be contradicted by the Minister, that he knew all about it, was consulted on Sunday afternoon with the Minister of State about all of the amendments that were going to be put forward. Yeah. He changed them, he amended them, adapted them and contributed to the press release. I was so disappointed that Lord Sharp wasn't on the radio explaining it all on that Monday morning on the Today programme, because that would have convinced me that it wasn't a prime ministerial coup against the Home Office. But the fact of the matter is, there is no way for new amendments to be introduced into the bill. That's the point. That's the serious point through humour that I'm trying to make. And the whole debate is about the threshold. Lord Hope, in a really interesting contribution, I've never been a vice deputy chair of the Supreme Court, but in debating with Lord Hope and what he said to me, that my amendment is deficient. It's a fair criticism to make, but what I'm seeking to do in my amendment, with the support of Lord Paddock, Baroness Jones and Baroness Chakrabarty, is to say, such is the importance of protest, that we want a serious disruption to have a high threshold to be proved. And the first part of that is an attempt to deal with the point that Lord Hope made and others made in the Constitution Committee. We took advice to make it relevant to this Act. We asked people how to make it relevant, and they said by the inclusion of the first 3 lines of the amendment, without reading it out, that makes it relevant. Now, Lord Hope may criticise me for saying that isn't the case, but that's the advice that we had. I would say to Lord Hope, in quoting, and this is where I criticised the amendment that Lord Hope and supported by others would make, and this is the point that the Constitution Committee quite rightly says, that serious disruption should be put on the face of the bill, but it also says should be clarified in the bill in a proportionate way. My contention to this chamber is that the threshold that Lord Hope and others have put is not proportionate. It sets the bar so low that even as we debated this amendment in this House, we had people, Lord Berkeley, proposing, wouldn't it be better if you'd have said major rather than minor? Lord Hope having to say, I don't just mean minor, it's the word more in front of it that is extremely important. In other words, we start to debate what the court itself would be debating whatever the words that were there would be. And that was the point I was making to Lord Panic when he basically had a go at my amendment. Didn't put it quite like that. No, the noble and learned lords do not put it in the way that I might in with some of the debates that I had. But Lord Panic made a very interesting point that my amendment did not deal with that. But the point I'm making is, however you define it, it is the court in the end. However it's defined, in Lord Hope's way, in my suggested way, the court will define it. The court will have to determine whether that threshold has been met. And my contention is that setting the threshold at the bar that Lord Hope has set, at that low threshold, more than minor, a hindrance, as Lady Butler-Schloss has just said, a hindrance to something that actually doesn't have to have occurred. It doesn't have to have caused serious disruption. It has to simply be capable of causing it. How on earth are you going to work that out in a court? And yet we're going to pass clauses with offences linked to them, if these amendments are passed, which will allow a court to actually convict someone on the basis that it was potentially capable of causing serious disruption. Well, good luck with that. And I just say I want a serious threshold. This is a really serious group of amendments. And I say this to all noble lords in considering how they vote, because I will push Amendment 1 to a vote. In considering this, these amendments have been introduced in the light of the serious disruption that we've seen that we all think is unacceptable. But that is no way to legislate. It's no way to legislate to say, I'm so irritated, I've got to be seen to be doing something. It doesn't matter whether it's needed. We believe the police have the existing powers. The Chief Constable of Greater Manchester said, no wonder people are annoyed with us. The police should use the existing powers that they have. And the question for this chamber is, why is it that the confidence of the police has been eroded to such an extent they won't use the powers they've got because they're so worried about what the impact of that will be? That's the fundamental question. You can give the police whatever powers they want. If they haven't got the confidence to use it, they won't use it and it won't make any difference. So that's the point we're making with that. I tell you what will happen. I'll tell you what's going to happen. We're going to pass bad legislation here with respect to serious disruption. And a protest in a few months or a year or 2 years, somebody's going to try and take a protest, like the one I identified, where we linked arms, we attached arms. That, under this bill, you don't have to glue yourself. You can attach yourself by holding arms. So I don't know what protest people have been on. Who hasn't done that? I would think even lots of members on the opposite side of the chamber will have linked arms about something. I can think of a few protests, I won't mention them, but I can think of a few protests where many noble lords opposite will have linked arms. I suspect many of them will have been on a road. I suspect many of them linking arms will actually have blocked the traffic. I've certainly seen a few outside here, weren't necessarily Labour supporters from what I saw of it, who were doing that. But the point I'm making is that we are going to pass legislation here where protests that all of us would regard as reasonable, all of us would regard as acceptable, are going to be made illegal. Protests that involve, and I'll use this in the last example and stop. I use the example and I use it again. A bus company changed its route in an area where I was the local councillor. It changed its route to run it as a bus right through the middle of a estate, plus children's playgrounds, nurseries and a housing estate. We objected to that, the community objected. And to get the bus company to change its mind, we linked arms across the road to stop the bus coming down it. There were people going to work on that bus, and I don't know who else, but we stopped that bus going down that road. That wasn't just me as a Labour agitator, it was mums, it was grandmums, and I know I said this in my original remarks, but it's so important it was ordinary people standing up against the reckless decision of a bus company that took no notice about the safety of children. They wanted their bus to go down it, and we weren't having it. And we linked arms, and we stopped that bus coming down the road. That affected, that hindered, more than minor, Lord Hope, I would say that is. Although, I don't know, might have to be major. But more than minor. But the point I'm making is this. We changed that bus company, we changed its mind. It moved from having that bus going through an estate past children to going on its original route. That is banned. It will not be allowed by what the government are proposing here. Even if serious disruption is defined in the way that Lord Hope wants, it will not be allowed. And there are countless examples, and I would ask each and every one of you to think about times where you may have protested, times where you may have taken action. And I tell you, there will be times from each of us that under this legislation will not be allowed. And that is why my Amendment 1 is so important. It seeks to say to the courts and to the police and to others that of course you have a right to protest, but to stop that there must be a proof of serious disruption. And in the end it comes down to, do you want a low bar as Lord Hope wants, or do you want a higher bar as Amendment 1 proposes? I think Amendment 1 seeks to protect the right to protest, and as such this chamber should support it.
The question is that Amendment 1 be agreed to. As many as are of that opinion will say content.
Content.
The contrary not content.
Not content.
Content. Content. The question will be decided by division. I will advise the House when voting is open.
My Lords.
Order.
My Lords, the question is that Amendment 1 be agreed to. As many as are of that opinion will say content. Content. To the contrary, not content.
No content.
The contents will go to the right by the throne, the not contents to the left by the bar. My Lords, the question is that Amendment 1 be agreed to. My Lords, there have voted contents 243, not contents 221. So, my Lords, the contents have it.
Well done. Well done.
My Lords,
Order.
In view of the fact that Amendment 1 has been agreed, I thought it might be for the convenience of the House if I reminded the House that I shall not subsequently be able to call Amendments 5, 14 or 24 by reason of preemption. My Lords, in Clause 1, Amendment 2, Baroness Chakrabarty.
My Lords, first thank you. And Cole Porter thanks you from the grave as well, because how strange the change would have been from major to just a little bit more than minor. So my Lords, this second group deals with the concept of reasonable excuse, which noble Lords will remember is present in a number of the new criminal offences in the bill, some of which, not all of which, but some in particular locking on are very vague and dangerous, as noble Lords have heard. I have some amendments with the noble and learned Lord Brown of Eton under Hayward that attempt to set straight a reversed burden of proof inappropriate for the criminal law, where the government has sought to place the burden on the innocent cyclist with the bike clock or protester or whatever to demonstrate that they did not have a reasonable excuse, when really the lack of a reasonable excuse should be a component part of the criminal offence, and indeed something that a police officer considers before arresting someone. I think it's the noble Lord Paddock who has said eloquently many times in your Lordship's house that criminal offences need to be fit for purpose, not just in a courtroom or even during a charging decision in a police station. They need to be fit for purpose on the ground when an officer is considering who to arrest. And therefore it is important that the lack of a reasonable excuse be a component, core part of the offence and not something that a hapless bystander or protester has to prove. The noble Lord Paddock will speak to other amendments in this group that he has tabled, and I support all of them, whether my name is there or not. It's there in spirit. I'd like to be clear about that. That similarly attempt to improve these offences and improve the definition of reasonable excuse. But I just want to focus in particular on account of time and so as to prioritise the importance of not supporting the government amendments, or should I say the amendments that government ministers have now signed in the name of the noble and learned Lord Hope of Craighead. It seems harsh, to say the least, to single out protest of all the potential excuses that may or may not be reasonable in a particular case, a particular set of circumstances. Why single out protest as something that can never be reasonable? And that seems to me an attempt to take proportionality out of the mind of a decision maker, not just a court, not just but actually a police officer on the ground, and that I think is a mistake. Now, the noble and learned Lord Hope will no doubt cite authority, very leading authority, about circumstances in which proportionality is so clearly part of an offence that there isn't the need for a second guessing at the arrest or prosecution stage. But that will not be the case in relation to some of these offences, and I would venture locking on in particular. I will not attempt to repeat the eloquence of my noble friend Lord Coker with the various descriptions of linking arms, but the idea that an offence that can be committed with such trivial activity should not have an element of proportionality put in the mind of a decision maker. That's a huge concern to me. So without further ado, I commend the various amendments that I've described, but also ask people not to support any attempt to single out protest as the one excuse that is never reasonable. That seems rather unreasonable to me.
I'd like to move. Amendment proposed, clause 1, page 1, line 5, at end insert, without reasonable excuse.
My Lords, I support the noble Baroness on these amendments, and I am opposed to the proposed government and Lord Hope's amendment, Amendment 8, which seeks to exclude, narrow down very dramatically the scope which should, I submit, be present in this offence for a defence of reasonable excuse. And why should not a demonstration against measures concerning, for example, climate change, as a question of fact and degree for the trial judge, be adjudged reasonable, as indeed was the case in the Ziegler case, the DPP in Ziegler, which went to the Supreme Court. Now, it's perfectly true, and it's perfectly right that I should acknowledge this. The noble and learned, my noble and friend Lord Hope, indeed drew my attention way back at the end of last year to the later Supreme Court's decision, which he mentioned today with regard to Group 1, in the Northern Ireland abortion case. It's a reference from the Attorney General of Northern Ireland. And it is perfectly true to say that you can have crimes defined in such a way that they can properly be said to have taken account, insofar as was necessary, of Articles 10 and 11 of the Convention, and the criminality is already such as to justify, if the actus reus, the facts of the criminality are established, that is the offence with no scope for a reasonable excuse. And this watered-down version of that, an exclusion of the possibility of contending for the rights of protest and demonstration against matters of public concern, public debate, is a version of that. But it needs criminality of a serious sort, that countervailing interest, to justify any change to the ordinary position such as was arrived at in Ziegler, where the Crown or the prosecution have to disprove that you have a reasonable excuse, and a reasonable excuse, as in Ziegler, can perfectly well be a matter of public concern. And I would respectfully simply remind your lordships of the fact which this Northern Ireland case didn't question the actual result of Ziegler, which was to find reasonable excuse in these circumstances. And basically the facts there were that the demonstration was concerned with objections to the arms trade, and the demonstrators in that particular case held to have acted lawfully. What they did was they blocked off one side of a dual carriageway approach road to an exhibition centre. They prevented the traffic from going to the exhibition centre. They prevented the delivery of arms to the exhibition, and they were there for 90 minutes before they were cleared by the police, and that was found to be perfectly capable of providing the reasonable excuse defence. And so I would respectfully submit, should the position be here, it's a matter then for the court to adjudge the proportionality of the obstruction or disruption which occurs. And I would simply remind your lordships of this. It's really very important not to depreciate in any way this rightly valued historic rights of protest and demonstration. The fact is that it operates as a valuable safety valve. Not everybody who demonstrates is entirely logical, sensible, reasonable. Ratiocination is not necessarily behind it. There are disaffected, disillusioned, disenchanted people. And frankly, you weaken the defence of reasonable excuse, you weaken the position of the right to protest at your peril. Now, it's true that, for example, an example was given at second reading, that there may be countervailing interests, such as there's a strong public interest, for example, with regard to not carrying bladed articles. They shouldn't be carried in public without good reason. And in that particular case, the courts rightly, I would respectfully say, held that justified the burden of proof being on the defence to prove a reasonable excuse for carrying a bladed weapon. But I would respectfully submit that the criminality necessarily involved in an offence under this legislation, despite the sensible, if I may say so, vote on the first group, does not justify putting the burden on the defence. It should be for the Crown to disprove.
My Lords, I hesitate to participate in a legal argument when I'm not legally qualified, particularly when I wrote this in isolation at the weekend. However, there are two separate and distinct groups of amendments contained within this group. The group that I have amendments in are about whether someone has a reasonable excuse for their actions, or whether they should only have a defence of reasonable excuse once charged with the offence. In other words, does reasonable excuse mean they don't commit the offence, or should they be arrested, charged, and then only then have a defence of reasonable excuse? On the question of when, the second group of amendments are about the definition of what amounts to reasonable excuse. On the question of when reasonable excuse can be deployed, I have amendments 9, 16, 26, 32 and 36 in this group, which are intended to have a similar effect to amendments 2, 6, 11, 15, 18, 25 and 34 in the name of the noble Lady Baroness Chakrabarti. And in kind, I would say I am just as supportive of the noble Baroness's amendments as of my own. In fact, bearing in mind it's the combined efforts of, or with the support of the noble learned Lord Brown of Eton under Haywood, I'm sure that the noble Baroness's amendments are to be preferred. But they are designed to ensure that a person does not commit the offence to which the amendments refer if the person committing the act in question has a reasonable excuse for their actions, instead of, as currently drafted, if a person has a reasonable excuse, they can only use it as a defence once charged. The offences to which these amendments apply are locking on Clause 1, tunnelling Clause 3, being present in a tunnel Clause 4, obstruction of major transport works Clause 6, and interference with key national infrastructure Clause 7. So, for example, Amendment 16 provides that a person does not commit an offence if they have a reasonable excuse for tunnelling. In this case, in this clause, the government gives an example of a reasonable excuse as someone who was authorised by a person with an interest in the land which entitled them to authorise the tunnel's creation. Surely someone properly authorised to construct a tunnel should not be arrested and charged with tunnelling and only then be able to deploy that defence when they are clearly not guilty of that offence from the outset. The Minister may argue that the police will use their discretion, but we saw in the case of the accredited and documented broadcast journalist Charlotte Lynch, who while reporting on a Stop Oil protest was arrested, handcuffed and held in police custody for 5 hours for conspiracy to commit a public nuisance. The police using their discretion to avoid the detention of innocent people is not their strongest suit, at least not in public order situations. Perhaps I should remind the House I'm a former police officer. The Minister may say that the police have to be able to act quickly and decisively in public order situations, and that determining whether someone has a reasonable excuse is difficult in such situations. If he were to say that, is the government's position that innocent, peaceful protesters should expect to be arrested and detained by the police, even if they have a reasonable excuse for their actions? The chilling effect on people's right to protest would make such a stance reprehensible. The other amendments in this group are to do with the limitation of what amounts to a reasonable excuse. And I agree broadly with what the noble and learned Lord Brown of Eton under Haywood has just said. Yet again, the noble and learned Lord Hope of Craighead has secured government support for his amendments 8, 17, 18, 27, 28, 33 and 37. The government seeks to extend the proposed limitation to the offences of highway obstruction and public nuisance by means of amendments 50 and 51, respectively. The noble Lord Sandhurst comes up with his own alternative with Amendment 55. My Lords, I was taken with the debate we had at committee stage, and I said to the noble and learned Lord Hope at the time. In summary, the noble and learned Lord suggested that, taken to its limits, provided the reason for the protest was sufficiently serious, any criminal action, however serious, could be seen as reasonable. So, for example, if the purpose of the protest was to save the planet, surely nothing could be more serious, and so protesters could argue that that gave them carte blanche to do whatever they wanted. Hence, these amendments, signed by the government, seek to remove any issue of current debate from constituting a reasonable excuse. The argument is that it is the legislature that should set out clearly the limits of reasonable excuse rather than the courts, as recommended by the Constitution Committee. In his letter of the 23rd of January, the Noble Lord the Minister cites two Supreme Court cases, that of DPP versus Ziegler and others, referenced by the Attorney General for Northern Ireland Abortion Services Safe Access Zones Northern Ireland Bill. As I keep saying, I'm not a lawyer and I hesitate to offer a lay opinion, but in Ziegler, the Minister rightly cites Articles 10 and 11 of the European Convention of Human Rights as saying offers some reasonable excuse for obstructing others. He then cites the judgment in the Northern Ireland case that during a criminal trial it is not always necessary to assess whether a conviction for an offence would be a proportionate interference with the defendant's rights under Articles 9, 10 and 11. But my understanding is that this is the case only when the restriction of the exercise of convention rights is prescribed by the law in question, and the law pursues a legitimate aim, and the law is proportionate. My understanding is that the protection of the European Convention of Human Rights does not need to be considered in a criminal trial if and only if the offence explicitly restricts those convention rights, for example, being present in an abortion clinic buffer zone, that the offence pursues a legitimate aim, the protection of women seeking an abortion in that case, and is proportionate, and in that case it's limited to 150 metres around the clinic. For me, the question is whether the amendments in the name of the Noble and Learned Lord Hoper Craighead meet the three tests cited by the Supreme Court in the Northern Ireland case. If accepted, taking Clause 8 as an example, the restriction on a person's convention rights by excluding issues of current debate from being a reasonable excuse would clearly be prescribed if the Noble Lord's amendment was accepted, then that would be prescribed in law. That's the first. That would be the first condition. It might even be considered to be pursuing a legitimate aim in preventing someone from causing serious disruption by locking on. But I believe it fails in being disproportionate in that it would apply to every attempt to exercise a person's convention rights, no matter what the circumstances. Take, for example, the march against the war in Iraq in February 2003, where the official estimate was 750,000 participants. The BBC reported over 1 million people took part. The march brought central London to a standstill, and by any definition, serious disruption was caused. Are we really saying that the purpose of the march, in that case the war in Iraq, then an issue of current debate, should not be taken into account by the courts when considering whether the protesters had a reasonable excuse for causing the serious disruption? I accept that this is a serious issue, but I do not accept that this is a serious solution in that it fails the Supreme Court's judgment's third test of proportionality. As with the case of serious disruption in the previous group, I believe the Noble and Learned Lord Hoper Craighead goes too far, as evidenced by the government's support for his amendments. In terms of reasonable excuse, that there should be no difference between a dozen extremists blocking the roads around Trafalgar Square because, for example, they believe COVID is a myth, and 1 million people blocking the roads around Trafalgar Square in protest against the war in Iraq, because the issue is of current debate about which they are protesting, cannot be taken into account when considering reasonable excuse. That cannot be right. The other concern I have with the Noble and Learned Lord's amendments is, and I quote, as part of or in furtherance of an issue of current debate. So would a protest by the Flat Earth Society that caused serious disruption be permitted because they could argue that they have a reasonable excuse for their actions and it wasn't an issue of current debate, but a protest in favour of additional support for families facing the cost of living crisis, those protesters would not be able to access a reasonable excuse defence. The amendment in the name of the Noble Lord Sandhurst seeks to overthrow the judgment of the Supreme Court in DPP versus Ziegler and others. If my understanding of the Noble Lord's amendment is correct, no protest that inconveniences members of the public would be lawful, nor could there be any reasonable excuse for such conduct. Needless to say, we do not support the Noble Lord's amendment. I accept the Constitution Committee's recommendation that, and I quote, "it is constitutionally unsatisfactory to leave to the courts the task of determining what might be a reasonable excuse, without Parliament indicating what it intends the defence to cover. But it surely cannot be the case that Parliament wants the courts to ignore what the protest is about when determining what might be a reasonable excuse. As my commander said to me when I presented my solution for rotating police officers between uniform and CID, I don't know what the answer is, but this isn't it. We oppose these amendments.
My Lords, in the absence of the noble and learned Lord Hope, temporarily from the Chamber, I speak to the amendments in his name, to which I've added my name, and the names of the noble Lord, the Minister, have also been added. And was the Constitution Committee, in its report published on the 11th of November 2022, considered the question of reasonable excuse, which is used, as has already been pointed out, in a number of contexts in this part of the bill, and pointed out that it was not defined. It also said, at paragraph 14 of its report, that the offence already requires intent, which might render redundant the need for a reasonable excuse. The committee considered it unsatisfactory to leave to the court the task of determining what might be a reasonable excuse, without Parliament indicating what it intends the defence to cover. Including a reasonable excuse defence invites arguments as to whether certain, but not other, political motivations might constitute an excuse. What the committee recommended was that unless a precise definition of reasonable excuse were provided, then the reasonable excuse defence should be removed from clauses 1, 3, 4 and 7, apart from anything else, in the interests of legal certainty. This was a report, my Lords, from a committee looking at the constitutional aspects of the bill. It included, as the House will know, peers from all parties and none. I confess to some uncertainty as to what the government kind of intended by originally including a defence of reasonable excuse. If you cause serious disruption by attaching yourself to an object or to land, or otherwise locking on as defined in the bill, and you do so intentionally or recklessly, what could provide a reasonable excuse for your doing so? It seems to me that probably the only excuse that would or could be offered would be that your cause is a noble one, in particular that you are concerned about the damage to the planet caused by climate change. I see the noble Lord Deben taking a close interest in this debate, although I'm not suggesting for a moment that he'd be inclined to lock himself on. But the stance taken by Extinction Rebellion and Just Stop Oil has been, as we know, and it could be argued that any demonstration, however serious the disruption, is justifiable if it contributes in some way to providing extra pressure on the government to take appropriate steps to, if not completely turn back climate change, then at least substantially to reduce its effect. But I suspect that the reason why the reasonable excuse was put in the bill was an attempt to ensure that the bill then complied with the Human Rights Act. In particular, that it did not contain provisions which, in the light of the Supreme Court's decision in Ziegler, might be said to be in breach of a demonstrator's convention rights. The Ziegler decision has been controversial. Policy Exchange in particular, and a number of publications, has pointed out the flaws in the judgment, or at least the flaws in how the judgment has been interpreted. And since the Supreme Court decision in Ziegler, there have been other cases which seem significantly to water down its effect, the case of Kerkerian and the Colston Statute case. However, the recent decision in the Northern Ireland abortion case, handed down on the 7th of December 2022, after the bill has progressed a long way in the Lordship's House, has made it perfectly clear that Ziegler needs to be very substantially qualified. The ingredients of an offence can themselves ensure that it will be compatible with convention rights, even if it does not include a defence of reasonable or lawful excuse. It would be perfectly convention compliant, in my view, to remove the defence of reasonable or lawful excuse altogether. And I have to say that was my original preference. But I have been persuaded that it's better to retain the defence giving the possibility of a reasonable excuse that's restricted in the way the amendment allows. It will not be enough to say in relation to the offence that there is a worthwhile cause, such as combating climate change, and to say that that is a reasonable excuse, and ask a fact-finding tribunal, whether it be magistrates or even a jury, to give their views as to whether a reasonable excuse exists in the particular circumstances. On the analysis of the relevant jurisprudence in the Supreme Court in the Northern Ireland case, they referred to, among other cases, the well-known Animal Defenders case decided in 2013. That and the European Court of Human Rights case law shows that the state is granted a margin of appreciation in these areas. It will be a question of law rather than fact whether or not an offence sufficiently reflects the principle of proportionality. The prosecution will have to establish a serious disruption, and it will need to establish intention or at least recklessness. It seems to me entirely consistent with the Northern Ireland case that there is no need as a matter of law to provide for the free-ranging and really imprecise defence of reasonable excuse. And whilst the right to protest is extremely important, it's reflected in the ECHR just as it was in the common law before the Human Rights Act was enacted. But this right should be balanced with the right of our citizens to go about their everyday life without interference. Inconvenience is something we should be prepared to put up with, but where there is serious disruption involved, defined as the amendment which succeeded in the last debate will say, it should not be an answer for a defendant to say, my cause is so important that it trumps your right to go to hospital, to take your children to school, or to go to work. My Lords, this amendment is consistent with the law and consistent with what the vast majority of the population would want.
I'd like to support the group of amendments in the name of Lady Chakrabarti and Lord Brown. I mean, what they do is to require the police to prove that a person charged with an offence lacked reasonable excuse, rather than the person charged to prove that they had a reasonable excuse. In other words, it restores the presumption of innocence rather than guilt. And I think the presumption of innocence is not just an archaic legal point. The legal arguments, intricate legal arguments, are worthy of great respect, but I don't think they get to the heart of the matter. I mean, it's a cardinal, presumption of innocence is a cardinal principle of a liberal society. It's a cardinal political principle. Governments are always, or law enforcement agencies are always disposed to believe that their citizens are potential lawbreakers, I'm afraid, and therefore placing the burden of proof on the police is an essential safeguard for civil liberties. That seems to me the crucial point, because unless that is there as a cardinal political principle, you are reducing the extent to which police are answerable to the courts. And that is a very important, that's a point that lawyers should be very interested in. It reduces their accountability to the courts. And that's why in systems like Russia and China, it's very rare that you get an acquittal, because the presumption is that the person charged with an offence is guilty, and then the bias is all in favour of the conviction rather than the acquittal. So it's on the basis that this group of amendments embodies a fundamental political principle that I support it.
I could suggest to the House that we have to think a little beyond the precise legal issues which we've been concentrating upon. First of all, I was drawn into this discussion by a previous speaker, but I would remind him of my constant demand that we should take seriously the words of the Green Deputy Chancellor of Germany, who made it absolutely clear that behaviour which meant that ambulances couldn't get to hospitals and such like were unacceptable as well as counterproductive. So I don't think anybody would suggest that I've ever been a supporter of that kind of, and I don't think Noble Peer would have said that. But it does seem to me that the government has to face two very important questions. The first is really the one that referred to a march of 1 million people, which of its nature is bound to discommode large numbers of people. But as somebody who voted against a 3-line whip against the Iraq War, it seemed to me that unless you can accept that when something as appallingly wrong as that can result in large numbers of people saying, "Not in my name," you really can't run a democracy. I mean, that is absolutely essential. So I need to know from the government how they explain that their particular way of looking at this would not make illegal a march against the Iraq War. Because if that is not covered, then it seems to me that any of us who happen to believe in some really fundamental issues will have to find it very difficult to support the government. The second thing I think the government has actually got to explain is how it sees the position in which it puts the police. Now, I have to say this very carefully, but the truth is that the police's reputation is practically at its lowest ever. And I do think we have to ask the question as to whether this is the right moment in any way to put them into the political, small p, political position of making these kinds of decisions. That's why I voted against that ludicrous thing that we introduced, which was that you could be stopped from making a noise. The concept that somehow or other the police were going to say that if your protest was too noisy, they could stop you before you started. Well, I've never been on a protest that wasn't noisy and wasn't meant to be noisy, and noisiness was very essential. But we passed this. It was nonsense. It is nonsense. It'll never be imposed. The government argued for it. So the government's in a slight difficulty here because the argument I used against it was not only that it was balmy, which was obvious, but also that it would put the police in an embarrassing position at a time in which the police are of themselves.
Would my neighbour friend give way?
If I can just finish that sentence, are themselves in a difficult position. Then I give way to my long-lasting, what shall I say, judster.
Does my noble friend not agree that the insertion of the words contained in this amendment would place upon the police the initial duty of deciding what is or is not a reasonable excuse?
Well, I agree. I mean, that's what it says, so I don't disagree. I'm merely saying that I want the government to be very clear about what it is doing in terms of involving the police at a time in which may be not the most sensible time to do so. But there is a last thing that I want to say to the government, which is this. There are many serious issues which in a democracy we have to ask the government and the opposition to deal with. Some of those serious issues are not being satisfactorily dealt with. And there comes in a democracy a moment in which government has to say to itself, we are so unable to deal with this that we'll have to accept that there will be a significant increase in the public demonstration against where we are. Now, the government's pretty close to that on climate change, if I may say so, as the chairman of the Climate Change Committee. And therefore, I want the government to think to itself that if it insists on the further restriction of protest, it better think very clearly about the policies which it is carrying through on those issues where the public as a whole feel very strongly indeed. It is not an excuse to say that my view is so important that it is therefore a good excuse for marching. Otherwise, the Flat Earth Society or the Jehovah's Witnesses are in a position to be able to hold us all to ransom. But it is an issue for the government to think about, that in many areas it's got to realise that its policies must in some way reflect the deep-held worries and concerns of the public, or it doesn't matter how many laws it passes, because actually they won't be obeyed.
That's right. Lord Deben has made some very, very important points, in particular in relation to the police, and I think it's worth just elaborating a couple more sentences. The fact is, there are already great powers that the police have to deal with demonstrations, and the police simply don't use those powers, as Lord Deben suggested, partly because the police don't carry a huge amount of trust, and also the fact is these demonstrations do reflect a huge amount of feeling amongst the public, and the police do not wish to stand out against very strong feelings of the public. So to add further powers to the police is not going to be helpful, because the police simply will not use those powers either, for the reasons that Lord Deben has very brilliantly, as always, pointed out. So that's my main argument against these powers. There's no point in them. They're designed to frighten people not to go out on protests, but the police don't want these powers. They know that they wouldn't use them, and therefore they shouldn't be introduced by Parliament.
I rise to speak to my Amendment 55. In doing so, I am grateful and pleased to follow the speech of my noble friend Lord Folkes. My amendment addresses the legal difficulties caused by the judgment of the Supreme Court in 2021 in the case of Ziegler, in respect of offences in which it will be and will remain a defence for a person charged to prove that they had a lawful excuse or reasonable excuse for the act in question. The judgment in Ziegler concerned Section 137 of the Highways Act 1980. That section makes it an offence for a person without lawful authority or excuse wilfully to obstruct free passage along the highway. The Supreme Court ruled that the exercise of the Convention rights to freedom of expression and freedom of assembly and association, which might loosely be summarised as the right to protest, constituted lawful excuse. This has the effect that before a person may be convicted of obstructing the highway, the prosecution must prove that a conviction would be proportionate and thus justified interference with that person's convention rights. In practice, this has caused real difficulties to the police, who at times have appeared paralysed, and it's made it difficult for judges to run trials fairly and magistrates to reach decisions. My amendment leaves in the word reasonable. It doesn't make it a strict offence if you obstruct the highway. You can still do it if it's lawful authority or excuse. But what is to be judged in future would be what is done, the duration, the nature of what is done, not the fact that you have a high motive or what you consider to be a high motive, whether it's flat earth, anti-abortion protesters, it doesn't matter. So it's not whether you're a good person or you think you're a good person, it's what you're actually doing and whether you're stopping ambulances going about, stopping people going about their daily lives unreasonably and for too long. It means that the fact that conduct is intended or designed to influence government or public opinion will not of itself make it reasonable or lawful. And that is consistent with the jurisprudence of the Strasbourg Court. That court has said, and I stress this, in a democratic society based on the rule of law, political ideas which challenge the existing order and whose realization is advocated by peaceful means, must be afforded a proper opportunity of expression. But the law only protects the right to peaceful assembly. Articles 10 and 11 of the Convention establish that public authorities, for their part, are entitled to interfere with the right to protest for the legitimate purposes such as the prevention of disorder, the prevention of crime, and, importantly, the protection of the rights and freedoms of others. So it's not about stopping every march, but it is about stopping prolonged obstruction. That's what we're about. The Strasbourg Court has gone on to rule that the rights of the public include the right to move freely on public roads without restriction. So you have two rights here. You have a right to protest, but the general public also has a right to move freely on public roads without restriction. It's a balancing exercise. And the court has recognized further that states have a wide margin of appreciation in determining necessity when it comes to taking action against those who deliberately disrupt traffic or other aspects of normal life. So the right to protest in a public place exists, but it is not unfettered. It must be balanced against the rights of your fellow citizens. If the public is to be protected in the face of these novel types of protests, such as we have not seen before, which in their duration and nature go far beyond what is fair and reasonable, the police must be able to intervene and not be paralysed by anxiety. Peaceful assembly, ordinary marches, will still be protected. The public will still have to suffer and tolerate a measure of inconvenience and delay, but that will be within bounds. This amendment, my amendment, would end the state of affairs in which persons who obstruct the highway or damage property or seek to avoid arrest can distort and upset the proper balance by asserting their motive. Peaceful protest will be permitted, but the balance will be restored. And that is why, at the end of the amendment, it makes it plain that the section is to be treated as necessary in a democratic society for the protection of the rights and freedoms and others. So, henceforth, if my amendment was adopted, your assertion of a high motive will not suffice. It will be you'll be judged by what you did and how long it went on for and what was the effect on other people. Thank you.
As has just heard from my noble friend Lord Sandhurst, the essential area of law we're dealing with here is the proportionate interference with convention rights. And I agree respectfully with my noble friend that the decision of the Supreme Court in Ziegler does raise the question as to the correct balance and makes it, I would suggest, important for this House to legislate in this area. However, it is my misfortune to disagree with my noble friend Lord Sandhurst that this House should take the opportunity to overturn the decision in Ziegler. Rather, I would respectfully commend the approach of the noble and learned Lord Hope of Craighead, which has been set out for us this evening by Lord Folkes. Now, critically, the presumption of innocence is at the heart of our judicial process, and I would not think that any of these amendments cuts across the presumption of innocence. But there are three reasons why I would suggest that the amendment in the name of Lord Hope of Craighead, supported by the government, ought to be accepted. The first is the point made by the Constitution Committee that we need precision in this area. Second, however, there is a fundamental point. We should not be leaving this to the police or to the courts on a case-by-case basis. As Parliament, we should be taking the opportunity and indeed the responsibility to be drawing the bounds of the offences in this area. Third, however, we need to remember that at the moment, Section 3 of the Human Rights Act requires the court to read any legislation, if possible, consistently with the Convention, and absent, I would suggest, the amendment of the Noble Learned Lord, Lord Hope of Craighead, there is a real risk that the court will read down clauses in order to make them consistent with how the court considers Convention rights should be applied. On the basis of the approach of the Noble Lord, Lord Hope, we end up with a situation that there is scope for reasonable excuse, but it is limited. That means that we do not run the risk of the courts deciding the cases on an unanticipated or perhaps even incorrect basis. We also don't need, Parquet, my learned noble lords, Lord Sandhurst, we don't need to overturn Ziegler. What we will have, however, is a consistent, clear and precise approach to the criminal law, which is precisely what we ought to have. I accept that some of my colleagues at the bar may not be particularly happy with that, but I would suggest that in this area, and perhaps in others, their loss may indeed be the law's gain.
My Lords, in supporting Baroness Chakrabarty and Lord Brown's Amendment 2 and the points they've made, I wish to focus my remarks on Amendment 8 and the consequent amendments from that, which seek to define reasonable excuse defence, or a reasonable excuse defence. Can I start by saying I can't really believe the mess the government has got itself into on both the previous serious disruption definitions and now with respect to reasonable defence definition. It's frankly a mess. Nobody disagrees with Lord Fawkes again. I agree with the Constitutional Committee, as do most of us, I think, that it would be extremely helpful if there was a reasonable excuse defence defined on the face of the bill, and I don't think that's a point of disagreement between us, and the Constitutional Committee itself recommends that. But I've got to say, I mean, if you look at Amendment 8, and that's an example of the wording, and it's used in 17, 27, 33, and then it goes on in 50 and 51. And then offences related to that. I mean, what protest ever takes place that is not part of a current dispute? I mean, who protests because they're happy about something that is going on? I haven't seen any demonstrations saying how brilliant this is or brilliant that is. It might be an example. But usually there's a dispute takes place, a dispute happens and people protest about it. It's just logical. But in each of these amendments that we've got, you can't use an issue of current debate as a reasonable excuse in any circumstance. And this is what we're being asked to agree to in Clause 1, Clause 2, 3, lost my note, 1, 3, 4, 7, and then some of the later clauses. That's what we're being asked to. It contains a reasonable excuse defence at the moment. The Constitutional Committee says quite rightly it would help if that was defined. And the definition the government have supported says you can't use a current dispute as an excuse. I could go on at great length about that, but it just makes the point. It's ludicrous. And that's what the government, the amendment the government is supporting, are asking people to vote for. Somebody asked about an example. Well, I gave an example before of me in my situation, but let's give another example. Wheelchair activists lock themselves to Parliament gates, and I believe that has happened. I'm not certain, but I believe that has happened. So that's locking on. Okay? They can't use the fact they've done that, which will have caused quite a serious disruption to the actions of Parliament, I would suggest, particularly if it meant people couldn't come in. But they can't use the fact that they were protesting about disability rights, or their lack of them, as a reasonable excuse for doing it. Ludicrous. Absolutely ridiculous. But that's what the government amendment says. That's before it goes on to all the other things. Lord Deben mentioned about climate. Of course nobody agrees with the serious disruption that we've seen over the last year. That is a fallacious, ridiculous argument. We all agreed that much of that went too far. But you can't legislate about serious disruption in the previous group, or in this group legislate around reasonable excuse on the basis you're fed up with a few people and therefore you're going to do something about it. And you come up with an excuse, or rather a definition that simply doesn't make sense. I mean, I'll just say this in jest. Goodness only knows what the previous Prime Minister would have made of this, or the previous Prime Minister but one, who, if you remember, with respect to the third runway, said he was going to lie down in front of the first bulldozer. I mean, that would have been something. He would have been arrested for that. By his own party would have passed legislation to arrest him for it. I mean, in view of the time, I won't go on at great length. But willful obstruction of the highway, nobody can protest against any road. That's a current dispute, isn't it? If you've got a road going through the most beautiful countryside in the areas, imagine the area in which you live, and the council comes along or the government comes along, there's going to be a motorway right the middle way through it, or a road right the way through it. That's an issue of current dispute. You will not be able to do anything about it, or use a reasonable excuse that you protested against it. I know people will say this is willful obstruction of the highway. I know people can argue about tunnels and all this sort of thing, but willful obstruction, you won't be able to do anything about it because it's an issue, you won't be able to use reasonable excuse, it's an issue of current dispute. It's a nonsense. What about a railway line? I mean, HS2, I've seen Conservative MPs when the route of HS2 was being absolutely, it wasn't just, as I say, I know the government, it's the Labour Party, it's green activists, it's people who dress peculiarly, etc., who do it. But actually, Conservative MPs have been trying to obstruct or stop or delay HS2. Not allowed to do it. I mean, and this is the point, and I take Lord Fawkes' point, because in the end the court will wrestle with what reasonable excuse defence means. I understand that. But surely, my lords, it can't be right that in many of these amendments before us, using 8 as an example, this House is going to say you cannot use reasonable excuse where it is linked to a current dispute. I finish with where I started. What protest is not about a current dispute? I can't think of it. People don't protest unless there's a dispute about something. And yet the government are saying to us that that is what they want to pass. I think the Minister's got a really tough job defending the indefensible here. And I'd be interested in what he has to say, and I'm sure most of us would be, about how on earth you can put forward before this House an issue which is as serious as Lord Fawkes has said, and I accept that, but put forward something which actually just doesn't make sense. And actually, I think the government's in a real mess, and it ought to get itself out of it pretty quick.
My Lords, I clearly intend to shed some light. The Noble Lord Coker has generated a lot of heat on the question of the purpose of reasonable excuse. I would like to begin, firstly, by thanking the Noble Learned Lord Hope for tabling his amendments. These exclude protest as a reasonable excuse for the criminal offences within the bill. We would say that this amendment is consistent with the reasoning of the Court of Appeal in the Colston case in relation to the criminal damage allegations that were a matter at issue in that case. Furthermore, these amendments implement the House's Constitution Committee's recommendation that reasonable excuses in the bill are defined. And I would like, of course, to thank the committee for their thoughtful analysis in this regard, which has clearly helpfully informed much of today's debate. The amendments from the Noble and Learned Lord also follow from the Supreme Court's recent judgment that a lack of reasonable excuse in criminal offences is not necessarily incompatible with the European Convention on Human Rights. The Noble and Learned Lord Folkes has set out a compelling case for these amendments, so I will try to refrain from repeating these same points. Similarly, the Noble Lord Wolfson has very cogently set out the case for these amendments, and I won't repeat the points that he also made. In summary, the government supports these amendments. They are necessary to ensure that these criminal offences serve their purpose. The entire reason we are legislating is to make it clear that locking on, tunnelling and disrupting infrastructure are illegitimate tactics of protest. Now that we are satisfied that it is compatible with the European Convention on Human Rights to carve out protest as a reasonable excuse for these offences, we should do so. Parliament should make it explicitly clear that protest is not of itself a reasonable excuse for these offences. Not doing so will simply lead to protracted litigation in the courts. This much is clear from the Supreme Court's decision in the Northern Ireland abortion clinics case. Following from the Noble and Learned Lord's amendments, the government has tabled two more. The first similarly carves out protest of the offence of public nuisance. And of course, I would like to take the opportunity to remind the House that the former common law offence did not even have a reasonable excuse of the offence at all. One was included in statute on the recommendation of the Law Commission. Similarly, to the offences within this bill, and keeping in line with the recent case law, we should now carve protest out of the offence. The Second Amendment carves protest out of the lawful excuse of the offence of wilfully obstructing the highway. However, recognising that the offence is a low-level one, we do not carve it out in its entirety. Instead, the amendment only removes protest from the reasonable excuse where more than serious disruption is caused. The hope was to ensure consistency in the law. We sought to replicate the same proposed threshold of serious disruption in this offence. Therefore, protesters will still be able to obstruct highways to a certain degree. This, in the government's view, strikes the right balance between the rights of the public and the rights of protesters, an exercise that Lord Sandhurst rightly reminded the House is a fundamental part of the consideration of human rights. Despite Lord Hope's proposed definition now not standing part of the bill, there is still a need to clarify the circumstances in which obstructing a highway is not a legitimate exercise of one's Article 10 and 11 rights. I would expect the precise wording to be settled as the matter is debated further by Parliament, and in such a manner as to ensure consistency and clarity for protesters, the police and the courts. On the Noble Lord Debon's question on the impact of such an amendment on a march against the Iraq War, such as that we saw under the Blair administration. Under Section 3 of the Human Rights Act, this measure will still have to be read compatibly with the ECHR, the point that the noble Lord Wolfson made. Therefore, the point at which arrest and prosecution would be a proportionate interference with people's Article 10 and 11 rights depends on the circumstances of each protest. My noble friend Lord Sandhurst has tabled a similar amendment to those of Lord Hope and the government. This amendment...
I sit down on that little issue. I don't think I understand what he said. Is he saying that a march against the Iraq war would be acceptable under this act? After all, it is something which is about current issues. In fact, very few issues were more current at the time. So how is he saying that it would be, and how would people know in advance that it was? Because that's quite important too.
The reasonable excuse defence only arises once there has been a decision, obviously by the police, to prosecute. The fact of the march itself is something that the authorities would have to judge, and they would have to do so in accordance with their obligations to act lawfully and in pursuance with their obligations under the Human Rights Act, including those under the provisions of that Act. Returning, if I may, to Lord Sandhurst's amendment, that amendment removed protest from the reasonable, sought to remove protest from the reasonable and lawful excuses of all criminal offences. And whilst I appreciate the elegance of addressing the protest as a reasonable excuse question in one fell swoop, and agree with the sentiment behind it, and find interesting the research in the Policy Exchange paper, I cannot support the amendment. Some offences, such as minor obstruction of the highway, or the most minor damage, such as that caused by water-soluble paints or dyes, can be a legitimate exercise of Article 10 and 11 rights. The matter of burden of proof was debated at length during the committee stage. The government position remains that the burden of proof should rest on the defendant. They are aware of all the facts pertinent to their case. Indeed, as I made clear during committee, it is not a novel concept for the burden of proof to rest on the individual. I now turn to the amendments in this group in the name of the noble lady Baroness Chakrabarti and the noble Lord Paddock. These take issue with the reasonable excuse defence and seek to shift the burden of proving such a defence for the criminal offences from the defendant to the prosecution, making it a key element of the offence. Amendment 35, tabled by the noble lady Baroness Chakrabarti, also adds support for a trade dispute to the protected activities of acts wholly or mainly in contemplation of, or furtherance of a trade dispute under Clause 7. But the government position remains that the burden of proof should rest on the defendant. With regard to Amendment 35, whilst I understand the sentiment, the amendment is not necessary, as we assess support for a trade dispute would already be captured under the defence. I also want to address one of the criticisms made during the committee stage, which I believe has inspired some of the noble Lord Paddock's amendments. As I made clear during committee, the reasonable excuse defence resting on the individual does not, and would not, mean that those suspected of committing the offences would be arrested and charged without consideration of whether or not they had a reasonable excuse for their actions. With regard to the arrests, of course, Code G of the Police and Criminal Evidence Act 1984 states that the use of the power of arrest requires the belief that an individual is committing, has committed, or is about to commit an offence, and that the arrest is necessary. And, of course, with regards to charging decisions, the Crown Prosecution Service have to consider whether there is a realistic prospect of conviction at trial. Whether the suspect has a reasonable excuse will factor clearly in that decision-making process. This obligation on Crown prosecutors is set out in the Crown Prosecution Service's Code for Crown Prosecutors in paragraphs 4.6 and 4.7. Any reasonable excuse defence a suspect may have will be considered as part of these processes. Finally, I have considered the noble lady Baroness Chakrabarty's amendment to include support for a trade dispute in the reasonable excuse. I do not believe it's necessary, as an act in support of a trade dispute is in essence in furtherance of already in furtherance of one, and therefore already in the scope of the defence. As with the last group, I would encourage all noble lords to support Lord Hope's and the government's amendments and to reject the others.
Before the noble lord sits down, he said that the Northern Ireland case, the Supreme Court case, shows that the amendments are consistent with the European Convention on Human Rights. I made the point that the proportionality test that the Supreme Court made in that case was on the basis that the Convention rights were only restricted within 150 metres of an abortion clinic and not outside of that, whereas these amendments would apply universally and therefore, in my judgment, are disproportionate. The noble lord didn't address that issue.
Well, I can entirely understand that that's the noble lord's view. The test of proportionality will, of course, be decided on the facts of each case as it arises, and that will be matters that will feed into the decisions taken by the police and by the CPS in their charging process.
I'm grateful to all noble lords who spoke in an incredibly thoughtful debate. If I may say so, your lordship's house at its best. Noble lords will forgive me if I don't mention everyone for obvious reasons of time, but I'm particularly grateful to the noble and learned Lord Brown of Eton under Hayward for explaining that sometimes reverse burdens make sense, where the criminality is just so obvious, such as carrying a bladed article in public, but linking arms is not generally thought of as the same kind of criminality. Grateful also to the noble and self-deprecating Lord Paddock. He may not be a lawyer, but he is certainly a better lawyer than many of us lawyers would be as police officers, I suspect. And his brilliant exposition of the Northern Ireland case in particular, including by way of his last intervention, demonstrates that Ziegler is not dead. My lords, as we've heard from many noble lords in the thoughtful debate, protest is not a trump card. Protest will not always be a reasonable excuse for criminality, but sometimes it might be. It is not irrelevant to these matters. And good law, my lords, is about rules and discretion. And without the right amount of discretion, injustice will follow. But most of all, I am grateful to the noble Lord Deben, because it was his particular thought experiment that made me most concerned about a mass demonstration, such as Iraq, but it could be on another subject under another government in the future. A mass demonstration where, quite deliberately, the police do not run around arresting everybody. They use their discretion in the public interest not to do so, so as not to cause a very hazardous situation to human beings and public order, or because they simply would not be able to arrest a large number of people. So in my development of the noble Lord Deben's thought experiment, instead of just not arresting people and just ensuring people are safe, certain police officers arrest only a certain type of person. Say only the people in wheelchairs, or only the women who are easier to arrest, or dare I say it, only people of a certain race. Now, if those people alone were then prosecuted, and they were not permitted to argue a reasonable excuse that they were just on the demonstration like everybody else, my lords, I suggest that a grave injustice would follow. because the fact of the protest is not a trump card. It's never a trump card, but sometimes, my lords, it is highly pertinent. I shall not be moving these amendments in my name, because I have decided on the basis of this debate that the priority in the time we have is to vote against the government amendments. And that is what I would urge all those concerned about this to do.
Is it your Lordship's pleasure that the amendment be withdrawn? Amendment by leave withdrawn. Amendments 3 and 4, Lord Paddock, already debated, not moved. I'm unable to put Amendment 5 by reason of preemption. Amendment 6, Baroness Chakrabarti, already debated, not moved. Amendment 7, Lord Paddock, already debated, not moved. Amendment 8, Lord Hope.
Lord Hope. The House has heard this debate. I'm not going to repeat the arguments. They have been well set out. It is clear, I suggest, as a matter of law, that this is a perfectly sensible and legal amendment to the bill. It provides clarity. And the alternative approach is that police somehow have to assess the absence of reasonable excuse. It is a difficult balance to achieve. What this amendment does is to strike a balance between the undoubted and important right to protest and the right for people to go about their everyday life. My Lords, I commend this amendment to the House, and I wish to test the opinion.
Amendment be agreed to. As many as are of that opinion will say content. The contrary, not content.
Not content.
I think the not contents have it. The question will be decided by a division. I will advise the House when voting is open. Voting is now open. Clear the bar.
Order.
The question is that the amendment in the name of Lord Hope be agreed to. As many as are of that opinion will say content. The contrary, not content. The contents will go to the right by the throne, the not contents to the left by the bar. The question is that Amendment 8 be agreed to. There have voted contents 221, not contents 224. The not contents have it. We now come to the group beginning Amendment 9, Baroness Chakrabarti.
My Lord, so now we come to the next group. I've put my name to leaving out clauses 1 and 2, locking on and going equipped. I will not rehearse the problems with the vague nature of locking on, which at its lowest could literally be linking arms, or going equipped, which is a thought crime that could lead to people carrying all sorts of innocent items in their rucksacks, such as bicycle locks, or even in the context of the way that some journalists and photojournalists have been arrested of late, even potentially the camera that they were going to use to photograph the locking on because they knew there was a protest. The Noble Lord Paddock will speak to some amendments that he has tabled to tighten and improve some of the more serious offences that are discussed in the group, and the Minister will, of course, speak to the government amendments, which I don't believe to be, for once, incredibly controversial. But with that, I'll beg to move.
Amendment proposed. Leave out clause 1 as amended.
I'm rising to support the Noble Lady Baroness Chakrabarti. Quite honestly, we're trying to amend this awful piece of legislation, and really, it's not enough. We should just kick them all out, including these government amendments.
My Lords, I have amendments 19 and 31 in this group. As I explained in committee, the offence of causing serious disruption by being present in a tunnel, as drafted in the bill, could criminalise those in London underground tunnels, for example. Amendment 19 is designed to restrict the offence to tunnels constructed in contravention of Clause 3, that is, a tunnel created to cause or that is capable of causing serious disruption. I'm pleased to say that the Government agrees, albeit that their alternative Amendment 29 restricts the tunnels offence can be committed to a tunnel created for the purposes of or in connection with protests, whether the tunnel was created in contravention of Clause 3 or not. So they're not adopting the amendment that I put down, which is any tunnel that was built in contravention of Clause 3. They say a tunnel created for the purposes of or in connection with protest, whether the tunnel was created in contravention of Clause 3 or not. I know you shouldn't look a gift horse in the mouth, but can the Minister explain how being present in a tunnel that does not cause or is not capable of causing serious disruption, that is, a tunnel that was not created in contravention of Clause 3, can result in serious disruption being caused by a person being present in it? Why is it necessary to extend the definition of relevant tunnel beyond tunnels created in contravention of Clause 3? Why should the House agree to the Government's Amendments 21, 29 and 30 rather than my Amendment 19? I am sure the Minister will have been prepared to respond to that question. Or maybe not, looking at the Noble Lord at the moment. My Amendment 31 concerns the offence of being equipped for tunnelling, Clause 5. We believe that the offence of having an object with the intention that it may be used in the course or in connection with the commission of an offence of tunnelling is unnecessarily complicated. Can the Minister explain why the proposed alternative wording, having an object for use in the course of or in connection with the offence, is not sufficient? For example, Section 25 of the Theft Act 1968 states, and I quote, "A person should be guilty of an offence if, when not at his place of abode, he has with him any article for use in the course or in connection with any burglary, theft or cheat." What does "with the intention that it may be used" mean? Either the person intends to use the object or they don't, even if they may end up not using it, for example, because it might prove to be unnecessary. I've got this pickaxe in case the protest tunnel we're building encounters rocks, but if there are no rocks, I may not have to use it. Is still having the pickaxe for use in the course or in connection with tunnelling. In relation to the other amendments in the name of the Noble Lady Baroness Jacobati, supported by the Noble Lady Baroness Jones of Moulscombe and the Right Reverend Prelate, the Bishop of Bristol, seek to leave out clauses 1 and 2 from the bill. Locking on has been used for centuries as a form of protest, most notably by the suffragettes. This new offence is so widely and vaguely drawn, for example, to include people attaching themselves to other people without defining what attach means. Not only is there a right to protest, but there is also a long-standing acceptance that people should be able to protest in the way that they see fit. The creation of a locking on offence is not even supported by the majority of rank-and-file police officers, according to Her Majesty's Inspectorate of Constabulary, Fire and Rescue Services. And I quote, "Most interviewees did not wish to criminalise protest actions through the creation of a specific offence concerning locking on," unquote. As with the whole of this bill, there is sufficient existing legislation to cover locking on activity, whether highway obstruction, for which the penalty now includes a term of imprisonment, or public nuisance, where the maximum penalty is a prison sentence of 10 years. Can the Minister explain the circumstances in which locking on activity would not be covered by any existing legislation? In terms of Clause 2, when the offence of being equipped for locking on is concerned, as currently drafted, the offence of having something on them with the intention that it may be used in the course or in connection with the commission of a locking on offence by any person, not just the person in possession of the object, could potentially cover a whole range of everyday objects that someone is innocently in possession of. Whilst the offence presumably requires the prosecution to prove the intention that it may be used in the course of or in connection with an offence of locking on, power of the police to arrest is merely based on reasonable cause to suspect that an offence may have been committed, a very low bar. As I said in the debate of a similar clause under the Police Crime Sentencing and Courts Bill, you could buy a tube of superglue to repair a broken chair at home, then get caught up in a protest and be accused of going equipped to locking on. From my own extensive knowledge of policing, having a tube of superglue in your pocket, whilst innocently trying to negotiate your way round a protest, when you are stopped and searched by the police, as this bill will allow, and then believing you could convince the police officer that they do not have sufficient cause to suspect you are going equipped to lock on, and as a result that you should not be arrested, would be a triumph of hope over experience. We support Amendments 9 and 10.
I'll speak very briefly in support of the amendments to remove clauses 1 and 2 that my Right Reverend friend, the Bishop of Bristol, signed on to. She regrets she can't be in her place today. As the Noble Baroness Chakrabarti said, establishing new offences of locking on and being equipped for locking on have very significant consequences for the right to protest. A few days ago, I got an email from a retired vicar in my diocese. He wrote to tell me he's awaiting sentencing. He's just been convicted of obstruction by gluing himself to a road during a protest by an environmental group. The judge has warned him and his co-dependents they may go to prison. I cite his case not to approve of his actions, which I fear may serve to reduce public support for the cause that he has, rather than to increase it. I refer to it because it clearly indicates to me the police already have sufficient powers to intervene against those who are taking an active part in such protests. Anything extra, as Lord Paddock has just so eloquently illustrated, is, my Lord, superfluous.
And to my noble friend's very precise definition of the drawbacks of this clause, in more general terms, its provisions will lead to situations in which people do not know they're breaking the law and are then accused by the police of doing so. And I say do not know they're breaking the law, do not know they might be breaking the law because of its broad terms. That is a very unhelpful situation to arise, and it will arise, in my submission, quite frequently, because the sort of things that are covered by this provision are everyday household items, as my noble friend pointed out. Carrying glue, carrying a padlock. I referred in earlier debates, of course, to this practice of young people of placing a padlock on a bridge as a sign that they're eternally joined with each other, and throwing the key into the river so that it can't be taken off again. Imagine the conversation you're going to have with the police officer when you're trying to explain those circumstances and he thinks you're on your way to a protest. And I'm afraid that a secondary element to this general argument is that we have been reminded that if police officers abuse their powers, and a minority of police officers have clearly been doing so in a number of cases, then here are more powers that are rather too easily abused. To say to someone, well, you're resisting my clear observation that you're carrying something which could be used in a protest. You're creating a new situation in which women who are encouraged to be cautious about, for example, getting into a police car or accompanying a police officer, if he says, you better come with me, you're creating more situations in which that kind of problem can arise. And it's all completely unnecessary. Yeah. Existing powers can be used in all the threatening or worrying circumstances that this clause seeks to address. We don't need it, but worse than that, it's potentially damaging.
Yeah. My Lords, I was going to make a very brief intervention. I agree with both what my noble friend said in her introduction of this group, and also what the noble Lord Paddock said when he was talking about his amendments number 19 and 31, and looking forward to the noble Lord the Minister's explanation of Government Amendment 29 and how that is a more appropriate amendment than amendments 19 and 31. I thought one thing I could add to this interesting and short debate is, as a magistrate who regularly deals with the issue of reasonable excuse, and it is something which we've got used to dealing with over many years now. And of course, the context which I see that excuse is when somebody is carrying a knife or a bladed article, and that is almost invariably the defence that one hears when one is in court. And the only point I would make is that is something which we are used to dealing with, and it's also something which there is a lot of public interest in. And so changing definitions, giving more scope to more complex laws doesn't help the courts. The courts do have in these contexts the defence of reasonable excuse, and they're well used to dealing with it. But nevertheless, my lords, I think the amendments in this group have been well presented, and I look forward to the Minister's response.
My Lords, the amendments in this group take issue with offences listed in the first 5 clauses of the bill, so it might be helpful to set out exactly why this bill is so necessary and how it differs from existing public order legislation. The bill seeks to speed up the ability of police to preempt, intervene and respond to the evolving tactics we have seen and what can best be described as by a selfish minority of protesters, whilst establishing clear standalone offences which target disruptive and dangerous behaviour and impose sentences that are proportionate to the harm caused. My Lords, I've heard many times that the police already have powers necessary to deal with disruptive behaviour such as tunnelling or locking on. I must say I do disagree. We only have to look at the high levels of disruption as recently as a few months ago to see that more needs to be done. And I would suggest that this bill provides police with the powers necessary to combat these specific offences. The powers necessary, to combat these specific offences while ensuring that those who seek to cause serious disruption on private as well as public land are held to account. It is completely unfair that the hard-working public have to face misery and disruption caused by individuals locking on to a road or tunnelling under a building site, only to see the perpetrators arrested several hours after beginning their actions and then let off with a light sentence. Clauses 1 and 2 are a key part of the government's plans to protect the public from the dangerous and disruptive protest tactic of locking on. We have seen protesters who use lock-ons and who tunnel be acquitted on technicalities. It is therefore important to have clear, standalone offences for locking on and tunnelling to ensure that those intent on causing serious disruption for others can be brought to justice quickly and given a proportionate penalty that reflects the harms they have caused. The going equipped to lock on and the going equipped to tunnel offences enable the police to intervene earlier to prevent serious disruption. Dealing with a tunnel or a lock-on is extremely resource intensive, taking hours of police time, which could be spent much better tackling other crimes and disorder on our streets. Surely, noble lords would agree that enabling the police to act before the acts are committed is in everyone's best interest. My lords, the government is on the side of the public and will act to ensure the public are protected from these disruptive acts. We welcome Extinction Rebellion's sensible New Year resolution to prioritise attendance over arrest and relationships over roadblocks. However, Just Stop Oil and Insulate Britain are digging their heels in and have committed to continue trampling on the lives of others. Faced with this threat, it is clear to me that clauses 1 and 2 should stand part of the bill. Therefore, I respectfully ask the noble Baroness Chakrabarti, to withdraw her amendment. Turning to Amendment 19, tabled by the noble Lord Paddock, this amendment limits the extent of the offence of causing serious disruption by being present in a tunnel to tunnels which have been created through the commission of the offence of causing serious disruption by tunnelling. And I thank the noble Lord for tabling this amendment and accept the need for clarity in distinguishing between those who cause serious disruption in a tunnel created for the purposes or in connection with a protest and those who cause serious disruption in tunnels such as London Underground tunnels. My noble friend Lord Murray previously committed to considering this matter further. Subsequently, the government has tabled amendments 21, 29 and 30. These amendments provide that the offence of causing serious disruption by being present in a tunnel, as defined by Clause 4 of this bill, is committed only in relation to a tunnel that has been created for the purposes of or in connection with a protest. The Government's amendments provide clarity in the legislation on the scope of the offence, meaning that people who cause serious disruption in tunnels not created for the purpose of or in connection with a protest, such as the London Underground tunnels, would not fall within the scope of Clause 4. It also, in contrast to Amendment 19, includes no additional burden for the courts when prosecuting offences under Clause 4, in that they would not be required to show that an offence has occurred under Clause 3 as well. And finally, turning to Amendment 31, this amendment raises the threshold at which an object may be captured within the scope of going equipped to tunnel offence. Doing so would limit the effectiveness of the offence, and we are trying to ensure the police can act proactively before these harmful tactics are used. And the Noble Lord Paddock's amendment raises the threshold for intervention too high. In light of this, I hope Noble Lords will support the amendments in the Government's name and reject the other amendments in this group.
I'm grateful to all noble lords who spoke in this short debate. And I'd like to be clear with your lordships that the reason I believe it was such a short debate is because so much of the argument has been rehearsed in the first two groups. And I would say to the noble Lord the Minister, in thanking him for the tone of his remarks, that the reason why so many noble lords voted as they did in the first two groups is because of their profound concerns about things like the breadth and vagueness of these offences. So the shortness, the brevity of this debate is in no sense any indication of support for example, locking on, an offence that could find a courting couple, if that's not too antiquated a term to use, who linked arms and were capable of causing disruption to some off-duty police officers or on-duty police officers, and an argument ensued, and we're in the territory of locking on. And it was one of the revelations of debates around this bill to me when the noble Lord the Minister, now in his place Lord Sharp of Epsom, did in response to a challenge by one of my noble friends say yes, linking arms could be attachment. And there are reasons why people, for example, in a wheelchair might attach themselves to the wheelchair in order to feel safer during a busy demonstration. There are so many unintended consequences that, even if one thought it were legitimate to create specific, bespoke, is normally the phrase used by my noble friend Lord Ponsonby, bespoke offences to, for example, tackle the suffragettes of the future. This offence is so broad and so vague, it would catch people who don't even intend militant protest at all. And with respect to the noble Lord the Minister, when he tells us that the events of recent months make this legislation necessary, how does that square with the comments of the Right Reverend Prelate? The gluing to the road, which is an intended consequence to be caught by this, has already led to prosecution and conviction. And legislating doesn't stop bad things happen, but with bad legislation, even more bad things will happen, and the law will be brought into disrepute, and the relationship between the police and the public will be further fractured at a time when it is under grave strain for a number of reasons we need not rehearse. However, in the light of the first two votes, His Majesty's government is going to have to do some serious thinking before the further passage of this bill. And these offences and the definition of serious disruption and the issues of reasonable excuse and the need to protect journalists like Charlotte Lynch, who the noble Lord Paddock mentioned earlier, and a number of other journalists who have been arrested under existing offences like conspiracy to cause a public nuisance. No reasonable excuse for them before detention for many, many hours in the police station. The government is going to have to think again. And just in closing, because we may not get to the Journalist Protection Amendment this evening, when the Home Secretary appeared before Lady Hamway, who's in her place, Lady Hamway's Justice and Home Affairs Committee before Christmas, the Home Secretary, Ms Braverman, very kindly agreed to consider the amendment, the subsequent amendment in my name and the name of Baroness Boycott, to give specific protection to journalists. I've not heard a response from the Home Department yet. I have followed up with emails to the Home Secretary and to the public correspondence section of the Home Office, but I hope that before we reach that later amendment there could be some consideration, as was promised, to your Lordship's Justice and Home Affairs Committee before Christmas. But I shall not be moving the stand parts for the reasons I gave. I have every confidence that in the light of the last two votes, which may have come as a surprise to the government will sensibly now give some consideration to what is the appropriate way forward with this bill.
Is it your Lordship's pleasure that Amendment 9 be withdrawn? Amendment is by leave withdrawn. Amendment 10, Baroness Chakrabarti, not moved. Amendment 11, Baroness Chakrabarti, not moved. Amendment 12, Lord Paddock, not moved. Amendment 13, Lord Paddock, not moved. Amendment 14, Lord Hope of Craighead. Lord Fawkes, Lord Sharp of Epsom. Is this moved or not moved? It's preempted. Thank you. Sorry. Amendment 15, Baroness Chakrabarti, not moved. Amendment 16, Lord Paddock, not moved. Amendment 17, Lord Hope of Craighead, not...
He's not here.
He's not here. No, not moved. It's just not being preempted, I believe. Lord Sharp of Epsom had his name on the amendment. Not moved. Amendment 18, again Lord Hope of Craighead, not moved. Clause 4, Amendment 19, Lord Paddock, not moved. Amendment 20, Baroness Chakrabarti, not moved. Amendment 21, Lord Sharp of Epsom, moved formally. The question is that Amendment 21 be agreed to. As many as of that opinion will say content. The contrary not content. The contents have it. Amendment 22, Lord Paddock, not moved. Amendment 23, Lord Paddock, not moved. Amendment 24, Lord Hope of Craighead, not moved. Amendment 25, Baroness Chakrabarti, not moved. Amendment 26, Lord Paddock, not moved. Amendment 27, Lord Hope of Craighead, not moved. Amendment 28, Lord Hope of Craighead, not moved. Amendment 29, Lord Sharp of Epsom, moved formally. The question is that Amendment 29 be agreed to. As many as are of that opinion will say content. The contrary not content. The contents have it. Amendment 30, Lord Sharp of Epsom. The question is that Amendment 30 be agreed to. As many as of that opinion will say content. The contrary not content. The contents have it. In Clause 5, Lord Paddock, Amendment 31, not moved. In Clause 6, Lord Paddock, Amendment 32, not moved. Amendment 33, Lord Hope of Craighead, not moved. In Clause 7, Amendment 34, Baroness Chakrabarti, not Not moved. Amendment 35, Baroness Chakrabarty. Not moved. Amendment 36, Lord Paddock. Not moved. Amendment 37, Lord Hope of Craighead. Not moved. Amendment 38, Baroness Chakrabarty.
Thank you, my lords. So now we turn to the offence of interference with use or operation of key national infrastructure, which is clearly a matter of considerable concern to the life of the community and to this balance that we have been discussing between peaceful dissent and the rights and freedoms of other people in a democratic society. So the definition of what is key national infrastructure becomes very important in relation to a new criminal offence which attaches a maximum of 12 months in prison. And my Amendment 38 is perhaps fairly predictable for an amendment in your Lordship's House. It removes the Secretary of State's ability by regulations, by statutory instrument, to amend that definition of what is key infrastructure. Because as your Lordships will understand, it would be just too easy for any government, now or in the future, to amend the definition in a way that was not proportionate, to add matters and items to key infrastructure that the public did not consider to be key. So on principle, I personally don't think that criminal offences should be created or amended in that way by Henry VIII powers, and that is the reason for my Amendment 38. It's the sort of amendment that I would have tabled to any number of criminal justice bills. It's not specifically about protests. It's a principal objection to amending important definitions within the criminal law that way. And then in the group of the Noble Lord Paddock similarly tries to tighten important definitions with his 39 and 40, but I'll leave him to speak to those.
Amendment proposed, clause 7, page 7, line 39, leave out subsections 7 to 9.
Well, Lady Baroness Chakrabarty just said I have amendments 39 and 40 in this group. As we discussed at committee stage, whilst there may be some sympathy for measures designed to stop protesters blocking motorways, airport runways and railway lines, the legislation as drafted covering anyone who interferes with the use or operation of any key national infrastructure, including being reckless as to whether it could be interfered with, could criminalise those legitimately protesting on railway station forecourts or concourses, or those protesting outside or inside airport terminal buildings that are not intended to directly impact train journeys or flights. Clause 7, subclause 4, is extraordinarily broad in its scope, in that anything that prevents the infrastructure from being used or operated to any extent for any of its intended purposes is covered. For example, those waiting the arrival of a controversial figure whose presence is arguably against the public interest, who wish to demonstrate their objection to the person's presence in the United Kingdom, should be excluded from the overbroad remit of this offence. I accept that they may be committing other offences, but to be prosecuted for interference with the use of key national infrastructure, when this is clearly not the purpose or intention of the protest, does not appear to me to be right. Amendments 39 and 40 seek to restrict the offence to infrastructure that is essential for transporting goods and passengers by railway and by air, respectively. We support Amendment 38 in the name of the Noble Lady Baroness Chakrabarty in relation to the regulation-making powers of the Secretary of State to add, alter or delete the kinds of infrastructure covered by this offence.
My Lords, we support these amendments as well. As my noble friend Baroness Chakrabarti made clear in her introduction, her amendment, number 38, removes the Secretary of State's power to make regulations by statutory instrument, amending subsection 6 to add a kind of infrastructure, or to vary or remove a kind of infrastructure, or to amend section 8 or redefine any aspect of infrastructure included within the new criminal offence. And what she was trying to do, as she explained, was to try and get the Secretary of State to have a slightly more limited remit to introduce Henry VIII's powers along the lines she suggested within her amendment. The noble Lord Panic has explained his two amendments, numbers 39 and 40, very well. I won't repeat his explanation other than to say we are in favour of these amendments in general terms.
My Lords, turning to Amendment 38 in the name of the Noble Lady Baroness Chakrabarti, which seeks to remove the delegated power for the Secretary of State to amend, add or remove the list of infrastructure in the legal definition of key national infrastructure. My Lords, we've heard throughout the parliamentary passage of the Public Order Bill about ever-evolving protest tactics, targets and technology, and we therefore see it as entirely right that Clause 7 is accompanied by delegated power which will allow us to respond effectively to emerging threats. This was the position that was taken during committee stage when this amendment was first tabled, and it is still the position of the government now. I would like to assure the House that the power is subject to the draft affirmative procedure, thereby facilitating substantive parliamentary scrutiny. Turning to the Amendments 39 and 40 tabled by the Noble Lord Panic, Amendment 39 seeks to narrow the scope of rail infrastructure to exclude protests that do not directly impact on the operation of trains, whilst Amendment 40 seeks to narrow the scope of air transport infrastructure, excluding infrastructure that is not essential for the purpose of transporting passengers and goods by air. As previously noted, when these amendments were considered previously, the scope of the offence as drafted reflects the importance of the continued operation of the infrastructure as defined in Clause 8. And I'd be keen to hear from the Noble Lord Panic, what he deems to be the essential and perhaps inessential elements of rail and air transport infrastructure. The rail and air infrastructure are each complex, interconnected systems, and it is not an easy exercise to find rail and air infrastructure that you can describe as non-essential to the running of services.
The Noble Lord the Minister asked me to explain. Well, I explained in my opening remarks, which I accept are not reflected in his note. But if there was a protest at the arrivals part of an airport against somebody who people felt shouldn't be in the United Kingdom, then they could be criminalised by this offence as drafted, because it's interfering in some way with air transport, maybe in terms of arrivals, but not in terms of disrupting flights, which is, or in terms of the what the intention of the legislation is. The Noble Lord the Minister asked for an explanation. I have just given him one.
I'm very grateful to the Noble Lord for his explanation, but as I say, the rail and air infrastructure are each complex, interconnected systems, and it's not an easy exercise, as I said previously, to find rail and air infrastructure that you can describe as non-essential to the running of services. Adopting this carve-out could pose a risk of ambiguity as to whether certain facilities, sidings, depots, maintenance facilities, freight facilities, air infrastructure that is used for pilot training, air shows and potentially trials of flight aircraft and so on would be covered. It therefore creates ambiguity for the transport industry, the police and protesters, and would give protesters another opportunity to delay prosecutions where the prosecution has to prove that the infrastructure that was targeted was essential. I would also note that these are not safe places to be conducting a protest, though this hasn't necessarily stopped people in the past. It is therefore the Government's view that all parts of our rail and air transport infrastructure must be protected. For these reasons, my noble lords, I respectfully ask that these amendments be withdrawn.
Grateful once more to all noble lords who spoke in this short debate, and once more not testing the opinion of the House should in no way be taken as consent, let alone enthusiasm for what the government is doing here. My lords, the criminal law should be an exercise in precision technical drawing, not impressionist art. But this government and the Home Department in particular is painting with a very, very broad brush. And not just in terms of these broad powers and offences that we have debated at length, not just a blank cheque to police officers to use and misuse by accident or design, but it's a very blank cheque to the Secretary of State to further define and amend this serious criminal offence of interfering with key infrastructure without the proper scrutiny that comes to primary legislation. And I'm grateful to the noble Lord the Minister for at least giving me the assurance of the affirmative procedure. But the problem, of course, with the affirmative, even the affirmative procedure, is that at a time of great public concern about the next protest movement down the track, you know, the one that hasn't made the New Year's resolution that this particular minister approves of, is that a list of amendments will go in the regulations to what is to be key infrastructure, and some of them will be sensible and acceptable, and some of them will be outrageous. And members of the other place and members of your Lordship's House will be put in the invidious position of yes or no without the kind of scrutiny and line-by-line consideration and voting an amendment that is possible in relation to a criminal justice or public order bill. And this need to subdelegate seems all the more extraordinary, my lords, when we're getting public order bills every year at the moment. So that it just doesn't compute to me, but I've tested the patience. Having tested the patience of the noble lords and ministers, I won't test the opinion of the House.
Does the noble lady wish to withdraw her
Thank
amendment?
you. I should have said I wish to withdraw.
Is it your Lordship's pleasure that Amendment 38 be withdrawn? Amendment is by leave withdrawn. Amendment 39 in Clause 8, Lord Paddock, not moved. Amendment 40, Lord Paddock, not moved.
My Lords, I beg to move that the consideration on report now be adjourned until not before 8:15 p.m.
The question is that further consideration on report be now adjourned. As many as that opinion will say content. The contrary not content, the contents have it. So the House will be adjourned until 8:15. For the day, I didn't quite hear the time.
Sorry, for the dinner break, not before, and not resume until 8:15 before.
The House will resume after 8:15. Thank you. And I'll allow a few moments for people to move around in the chamber before we move to the next business.